Heard Mr. R.H.A. Ahmed. What is your name?
A.K. Azad.
Heard Mr. A.K. Azad, learned counsel for the petitioner, who prays for an adjournment due to personal difficulties. He submits that he has informed the counsel for the respondent side regarding his prayer for adjournment. The prayer is allowed. Let this matter be listed again on 19th of March, 18th of March.
Obliged.
Hey, please, your lordship. I beg to mention item number 39 up to the list, my lord. Orders matter, my lord. Darwin case, Mr. DJ Kapil is out of station, my lord. Can it be on 19th? Item number 39, my lord.
Heard Mr. What is your name?
A. Bhattacharjee, my lord.
Heard Mr. A. Bhattacharjee, learned counsel for the petitioner, who prays for an adjournment on the ground that the conducting counsel is out of session. The prayer is allowed. Let this matter be listed again on 19th of
Yes, highly honorable.
May please, your lordship. I wish to mention item number 11, my lord. My lord, I may be allowed to withdraw this petition with liberty to file a fresh, my lord.
Heard Mr. H.A. Ahmed, learned counsel for the petitioner, who prays for allowing the petitioner to withdraw the instant criminal petition with a liberty to file appropriate petition before appropriate forum. The prayer is allowed. This criminal petition is dismissed from withdrawal with the liberty sought for granted. Stop.
Highly honorable.
May I have lordship, I beg to mention item 26, my lord. In this case, my lord, scan copy of case record was called for. Office note says that is not received, my lord. So reminder may be issued and.
Heard Miss, what is your name?
My lord, I am Mohammed Ali, M. Ali, my lord, on behalf of H. Bhuya.
Heard Mr. M. Ali submitting on behalf of Mr. H. Bhuya, learned counsel for the petitioner. You have seen the office note
My lord.
dated?
Date
We will pass the order when the matter is called for.
lordship. But
May-
I have seen one. Obliged.
May I please, lordship, item 27
Yes.
on behalf of Mr. H. Chaudhary, my lord. This is personal difficulty to them, my lord.
Heard Mr. N. Mahajan, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel, Mr. H. Chaudhary. The prayer is, case diary is there,
No, not there. Not
learned. Case diary was called for.
Call for.
Learned additional public prosecutor, Mr. K.K. Das, prays for allowing some more time for producing the case diary. Prayer is allowed. Let this matter be listed again on 25th of March. 25th of March.
I'm sorry, my lord.
Obliged.
Office note, my lord, 10/3/25.
Office note dated Agar order of office note dated 10/3/2025 mentions that the scan copy of the case record which were called for have not yet arrived. Issue reminder for the same. List this matter again after 2 weeks on a date to be fixed by registry.
Obliged.
May I please, your lordship? POCSO matter, your lordship, charge sheeted case, your lordship.
Notice has been,
Notice, I have not received any report, lordship.
we have taken steps.
We have taken steps, your lordship. Your lordship, the last occasion directed the APP lordship regarding the service report.
Scan
your
copy is received.
Not received.
No, into
lordship. 9
office,
months behind. the
office
target.
note is there. Scan copy has been received. Where? Kotas. Heard Miss G. Bora, learned counsel for the petitioner. Also heard Mr. K.K. Das. It appears that the notice issued to respondent number 2 has not yet returned. Learned, when will you inform this court? You have to,
I will talk to the.
learned additional public prosecutor is requested to let this court know regarding about the fate of the notice issued to respondent number 2 after getting necessary instructions from the officer in charge of jurisdictional police station on the next date fixed. Stop. It also appears from office note dated 7/3/2025 that scan copy of the status report of the POXO case has been received. Stop. List this matter again on which, when will you inform?
Lordship, scan copy also need to be come, Lordship.
No, scan copy is there. Status report is there.
Okay, okay, Lordship, on 18, Lordship.
Let this case be listed again on 18th of March.
Which it is.
Yeah, based on that. Regular bill application, my lord. Proceed, petitioner behind the bar, 136 days, my lord, in between quantity, my lord. Notice for which was released by the honorable court, my lord.
136.
Days, my lord. Now, proceed, the petitioner, FIRS page 13, my lord. May I read, my lord?
What was seized?
Proceed. Proceed, the relevant person is page 16, my lord. What happened, my lord? Page 16, my lord, type copy. The powdery substance kept inside the soap case-like containers suspected to be brown sugar are weighed by me with the help of digital weighting machine belonging to Kaline PS. In presence of witnesses, total net weight is
What was the weight?
my lord,
What was the weight of the contract?
69 grams, my lord.
Only 69
One
grams.
gram. I'm told is released by the honorable court. my lord.
Did you remember?
No, then he cannot be detained.
Oh, if it is.
69
Lordship.
grams. It is intermediate quantity.
He was the owner of the car, my lord. And he was the driver, my lord. And the owner of the car asked him to come Meghalaya, my lord, to lift the petition, lift the accused person. On the way, police arrested the petitioner.
Where is the seizure list?
Lordship, consider this case page 25, my lord.
Why your prayer was rejected by the trial court?
My lord, charge sheet has been filed on the ground.
Where is the rejection order?
Yes, so, Lordship, I could not annex, my lord. Lordship, kindly see at page 38, my lord.
Now, why have you not annexed the
Page
rejection?
38, my lord. Rejection order. Two times rejected, all I have annexed, my lord. Last annexure, Lordship, page 40, my lord. Instance of the accused Ataur Rahman. Lordship, kindly see page 40. As per instruction, accused Ataur Rahman, who was released by the honorable court, my lord, in the vehicle bearing registration number so and so, case diary further reveals that one, the basis of the statement of the co-accused person,
Oh, it was a charge sheeted case.
my charge sheet case, my lord.
Okay.
Ataur Rahman was the owner, my lord. He and the petitioner, Lordship, is a driver to come to Meghalaya, my lord.
Then question of default bail does not arise.
Lordship, 136 days, my lord. Okay, video detention, my lord.
No. Then, yes, Mr. Das.
He was not aware about the my lord facts, my lord. He was a driver, my lord.
As this is charge sheet had submitted, Lordship, so it will have to be on merit, Lordship, then.
No, but they,
scan copy need to be called.
Who are the co-accused? How many charge sheet has been filed against how many persons?
3 persons, my lord. Lordship kindly see at page 32, my lord. 32. Number 1, my lord, Rachel Hussain, and number 2, my lord, A3, Ataur Rahman.
Who are on bail?
Uh, uh, I am for the Rachel Hussain, my lord.
Atabur is on bail.
Now release, my lord. He was the owner of the car, my lord. He directed the petitioner, my lord, to go to Meghalaya. He is waiting Meghalaya, my lord. He is a daily wages basis, my lord, petitioner, my lord, and the court he received some consideration and drive the car, my lord.
Heard, Mr. What is your name?
A with Laskar, my lord.
J.U.
And M. Laskar.
J.U.N.M. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 183 of BNSS has been filed by the petitioner, namely Rasel Hussain Laskar, who is detained behind the bars since 29/10/2024, within bracket for last 136 days, in connection with NDPS case number 155/2024, corresponding to Kaline PS case number 250/2024 under section 21B/29 of the NDPS Act, pending in the court of learned Session Judge Kachar. The gist of accusation in this case is that on where is the affair?
FIR page Lordship. Type copy start from Lordship page 12, my 13, my lord.
On 9/10/2024, one Maheshwari Das, SI of police, had lodged an affair before the officer in charge of Kalayan police station, inter alia, alleging that a secret information was received on 28/10/2024 through reliable sources regarding carrying of huge quantity of contraband in a vehicle bearing registration number AS01AM 0131. Stop. On the basis of the said information, a police team was constituted and a Naka checking was arranged at the Gorkhal toll gate. Stop. During Naka checking duty at about 7:35 p.m., one vehicle bearing registration number AS01AM 0131 was intercepted, wherein two occupants were found in the said vehicle, namely the present petitioner Rasel Hussain Laskar and one Raibul Hussain, RAEBUL, Raibul Hussain. During search of the said vehicle, 7 numbers of plastic soap cases were found wherein 69 grams of suspected heroin was there. On receipt of the said FIR, Kaline PS case number 250/24 was registered and investigation was initiated. Ultimately, on completion of investigation, charge sheet was laid against 3 numbers of accused persons, including the present petitioner. Stop. Learned counsel for the petitioner has submitted that the petitioner has been detained behind the bars since for last 136 days. And as the charge sheet has been laid, there is no requirement of his further custodial detention. He further submits that the quantity of contraband seized in this case is of intermediate quantity, and therefore there is no embargo of Section 37 of the NDPS Act 1985 in this case. He also submits that in the meanwhile, one of the co-accused, namely Atabur Rahman Laskar, has already been granted bail by this court by order dated 27/2/2025 in bail application number 507/2025. And therefore he prays for allowing the petitioner to go on bail. On the other hand, learned additional public prosecutor, Mr. K.K. Das, has opposed the grant of bail to the present petitioner on the ground that the offense involves offense is though offense involves intermediate quantity of contraband, it is it was found from conscious possession of the petitioner. And what else?
Charge sheet submitted, Lord Chief.
And as the charge sheet has been submitted, he does not have any right to get bail. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the records of this case. It appears that the quantity of contraband seized in this case is of intermediate quantity, and therefore there is no embargo of Section 37 of the NDPS Act. Stop. It also appears that in the meanwhile, one of the co-accused has already been released on bail by this court. Stop. In view of above, and also considering the fact that the petitioner has been detained behind the bars for last 136 days, his further custodial detention does not appear to be necessary if he cooperates in the trial. Stop. In view of above, the above named petitioner is allowed to go on bail of rupees 50,000 with one surety of like amount, subject to the satisfaction of the learned special judge Kachar, with following conditions, number 1 and 2. With above observation, this bail application is disposed of.
Please, Lordship. Kindly call for LCR.
Heard Mr. M. Rahman, learned counsel for the petitioner, also heard Mr. K.K. Das, learned additional public prosecutor. Perusal of the scanned copy of the trial court records would be necessary. Hence, what is your ground?
Long incarceration.
How much? How much time?
856 district.
850,
856.
800.
856 days total.
Okay. All for the case records of NDPS case and scan copy of the records of NDPS case number 7 1723 from the learned trial court. The registry to take steps for requisitioning the aforesaid case, scanned copies. Place this matter on 24th of March, 24th of March.
Obliged.
May please, your lordship. Intermediate quantity, diary may be called for.
Heard Mr. N.J. Dr. Learned counsel for the petitioner, also heard Mr. K.K. Das, Learned additional public prosecutor. Perusal of the case diary would be necessary for consideration of the instant bail application. Hence call for the case diary fixing
27 March.
27 March.
Six, my lord, it's a charge sheeted case, my lord. Lordship may call for the, my lord, the scanned copy, my lord. In fact, my lord, one submission I want to make, my lord, here, my lord. The case record has already been called for, my lord, in this instant case, my lord. In BA number 326624, my lord.
When is the date?
My lord, in fact, my lord, lordship had allowed that petition on, my lord, 19/2/2025.
What is your ground?
My lord, my ground is that, my lord, out of 8 witnesses, my lord, only 4 were, four witnesses.
How long are you
2 years,
behind the bar?
3 months, my lord.
Okay.
And in fact, my lord, that case, my lord, bail, lordship had allowed, my lord, 2 years, 2 months, my lord.
Heard Mr. N.J. Dr. Learned counsel for the petitioner. Also heard Mr. K.K. Das, Learned additional public prosecutor. The petitioner has prayed for bail in this case on the ground of prolonged incarceration. Stop. Let a status report of the trial of NDPS case number 30/2023 be called for from the trial court. Registry to send the requisition for the said status report. Let this matter be listed on 24th of March.
But the record is with that file, my lord.
Record may not be necessary.
I'm obliged, my lord.
Your lordship, the petitioner was taken into custody on 6/2/2025, and the section involved herein is 21B of the NDPS, but it has been wrongly attracted in this case as because your lordship in page number 18 of the FIR, it clearly states that only 1.9 gram has been recovered from the custody of both the persons, whereas not
Why your bail was rejected?
the bail was rejected on simply because it has been mentioned in the page number 27, your lordship. Considering the period of detention and the amount of recovery and the stage of investigation, I am not inclined to release the
But
accused.
amount of recovery,
Yes, now, no, see the amount of recovery, what is one?
it is pending investigation. Investigation is going on.
Investigation is going on, lordship, as per the FIR and the forwarding report.
We will call for the case diary.
It is a case of small quantity, your lordship, because based on the statement of the accused person on the other day, the other recovery items that were recovered on the statement of the accused person.
No, but the
Other accused person. On the 6th of the month of the February, both were apprehended while coming in a bike. He had no knowledge. that this
6.3 grams heroin,
1.9 grams.
6.3.
6.3 is recovered on the other day based on the statement of the co-accused person. And it cannot
From
be
whom? From whom?
from a drain. Based on the.
We'll call for the case diary. Call for the case diary. Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. Learned counsel for the petitioner submits that this is a case where small quantity of contraband is involved. However, on perusal of the order dated 2/11/2020, two bail order is when your bail was rejected
The bail was rejected on 3/3/2025.
on 3/3/2025. Pass well, learned Special Judge Morigao. It appears that the said prayer for bail was rejected after considering the quantity of contraband recovered. Therefore, perusal of the case diary is felt necessary in this case. Hence, call for the case diary.
21-3.
Let the matter be listed on 21.
Yeah. Page 14 is the FIR. Actually, it was a complaint lodged before the SP on 10/9/2024.
Also,
No, my lord, POCSO, not POCSO. It is yes, POCSO is sorry, my lord. POCSO is inserted. But petitioner arrested, she is a lady. Whether section POCSO is applicable to her, my lord? Petitioner is a lady. Now, number one.
maybe now POCSO is applicable.
Gender neutral.
It is a gender neutral. It may be
No,
applicable to.
If you also can say allegations. Now, my lord. There's 15 allegations. And now 90 days today I completed in the jail.
90 days.
90 days. When 11/12 he was
Why your
arrested.
bail was rejected by the trial court?
Yes, it was rejected because page 20. You will also get this. Earlier bail was rejected on 6/1/2025, and that is why page 20.
What is the accusation?
You will also say page 15. After a loss, complaint lodged before SP. SP forwarded the matter. After 1 month's case has been registered, my lord.
Now, what is the submission?
Submission, my lord, now already 91 days to I completed. Now,
Where is,
the
where
charge
is,
is not filed.
where is the date of arrest?
It also carries a forwarding report, my lord. 11/12, my lord.
Page number?
Page number, my lord. 18.
11/12.
11/12, my lord.
So from 11/12 today,
I am jail custody.
today is the 90th day.
91 days.
I need to take inside.
You
whether
take
Sasith
inside-
Charge is
submitted.
not submitted.
Let him find out whether charge sheet. We'll take it up after some time.
2/2.
Okay, too.
But my movement is charge is not.
Okay, let him find out.
Lordship, can we pass out the metaphor pending 9 and 10, Lordship?
Awesome.
Made PG Lordship. So this is an application under section 482 BNSS Melon. Lordship may kindly see the FIR, page number 19.
Yes,
Page number 19 is the FIR, my lord. The FIR relates to, my lord, some financial fraud, my lord.
page number
19, my lord.
19.
1.
Yes, what is
FIR
the
relates to
allegation?
some financial fraud by some persons, my lord. But the petitioner before your lordship, lordship may kindly see relevant page, why I am here, my lord. Page number 21. Lordship, there is a notice from the concerned police station to produce some documents, my lord, in relation to a vehicle. And lordship, I am a lordship second-hand car dealer, my lord. I have the registration number also. So one vehicle was sold to one Mr. Soriful Islam, my lord. In that respect, some documents were sought for from me side, my lord. I have furnished all the documents through WhatsApp, my lord, since I was out of station, my lord. But despite that, my lord, the police station have sent a mail to produce the documents, and over phone, they have been asking me to appear in person, my lord. The sale had taken place in the year 2022, my lord. Nothing else, my lord.
Then why are you apprehending?
Lordship, since I have already furnished the documents, my lord, they even then also, my lord, they are asking me to appear in person, my lord. That is why my apprehension arises, my lord. So I will appear, my lord, and produce all the documents in person, my lord.
Yes, yes.
Lordship, the crime deals with the cyber crime, Lordship. Here, the main crux of it is illegal racket, where he morphed the images of people from different locations across the country and fraudulently create numerous identity, Lordship, in order to gain wrongful gain from different financial companies by using electronic devices. So allegations are serious, Lordship.
No,
Yes,
but what is the accusation against him?
Lordship, yes, he has stated it is not in the FIR, Lordship, but he has stated that he is dealing with a
Why this vehicle was, whether it was,
Yes, lordship, may kindly see page number 14. I am a, my lord, registered second-hand car dealer. One person, namely Sofiul Islam, approached me in the year 2022, and that Sofiul Islam's name is also not in the FIR, my lord. That is why I also have no idea why I have been called for, my lord. Because I had sold the vehicle and I have annexed all the documents regarding sale transaction, my lord. But despite that, I have shared this, my transaction IDs, my lord. They are insisting on my personal appearance, my lord.
But if short date may be given, I will call Shidi, Lordship.
Lordship, I will appear.
no,
my
let
lord.
him appear. You call
I will
this.
appear, my lord.
But the allegations are serious, Lordship, frauding, dishonest,
No,
Criminal
if,
against other
if
individuals,
something is against him, if
Lordship.
something is found against him, you may pray for cancellation of interim bail. Heard Mr. T. Kolita, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner, namely Shri Jayanta Kolita, who is apprehending his arrest in connection with Moirabari PS case number 178/2024 under section 61 within bracket 2, 314 within bracket 2, 318 within bracket 4, 338/336 within bracket 3, 340 within bracket 2, 3 within bracket 5 of BNS, read with section 66C and 66D of the Information Technology Act. Stop. The gist of accusation in this case is that on 26/11/2024, one Jamini Basumatari, SI of police, had lodged an FIR before the officer in charge of Moirabari police station, inter alia alleging that an information has been received that one person, namely Nasir Ahmed, is running an illegal racket which used to morph the image of various persons and create fake identity by using electronic device and use and thereafter use the fake identity for committing various cyber crimes. So, learned counsel for the petitioner has submitted that petitioner has not been named in the FIR. Neither there is and he is in no way involved in the offense alleged in the FIR. Stop. However, he submits that on 1/3/2025, a notice was issued by the Additional Superintendent of Police Crime, Moregaon, under section 94 of BNSS to the present petitioner for seeking some information regarding a vehicle bearing registration number A01ES 0226. Learned counsel for the petitioner has submitted that the petitioner is a dealer of second-hand vehicles, and the vehicle about which information was sought was sold by him to whom?
Sorry, full Islam.
Shariful Islam. Learned counsel for the petitioner also submits that the petitioner provided all the documents relating to the said vehicle to whom you have provided?
Lordship, the telephone number they had provided in what
To
through
the,
WhatsApp only.
to the police through WhatsApp message. However, in spite of that, he is again called by the police station in person, by the police in person to the Moirabari police station. And therefore, he is apprehending that he may be arrested in connection with this case. Learned counsel submits that the petitioner is ready to cooperate in the investigation. On the other hand, learned additional public prosecutor submits that the offense involved in this case is of serious nature, and therefore perusal of the case diary would be necessary.
Honorable Lordship, though his name is not there, but the section 3(5) of BNS is there, Lordship.
Yes. He also submits that the complicity of the present petitioner in the offense can be ascertained only after perusal of the case diary, as section 3 within bracket 5 of BNS is also involved in this case. Call for the case diary. List this when
28th March.
fixing 28 March for the case diary. However, in the meanwhile, considering the submissions made by the learned counsel for the petitioner, as discussed here in above, the petitioner is directed to appear before the investigating officer of Moirabari PS case number 17X/2024 within a period of 7 days from the date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Moirabari PS case number 178/2024, the above named petitioner shall be allowed to go on interim bail of 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions 1 and 2. List as directed.
Much okay. Much.
May I please have one? My Lordship, FIR is on page 8, type to copy. My Lordship, may I read? It is respectfully stated that accused number 1, I am accused number 1, my Lordship. Nearly 2 years ago, lured my daughter Aklima Sultana, date of birth 16/3/2007, by deceiving her with various temptations and forced her into a romantic relationship. Subsequently, accused number 1, with the help of other accused persons, frequently manipulated my daughter, took her to his residence and forcefully committed sexual.
What is your
intercourse.
case?
My Lordship, my case is that I had love affair with the victim girl, my
Case
Lordship.
diary would be required.
And at that time, I was 18 years old and she was 16 years old. Now I am 21 years old, my Lordship. And our parents has executed an agreement, my Lordship. It may be seen annexure 2, page 14, my Lordship. They had agreed that they will solemnize our marriage, my Lordship, when we will attain our age of majority, my Lordship. Now, there are differences between our parents, my Lordship, and that's why that FIR has been lodged, my Lordship. I am 21 years old, my Lordship. I have not done anything. That annexure 4,
What is the date of alleged offense?
my Lordship. She is now 18 years old, my Lordship.
Date when the offense was committed.
My Lordship, as per FIR, my Lordship, no date has been given. It has been telling that 2 years, nearly 2 years ago, my lordship. Nearly 2 years ago, lewd my minor daughter.
What happened on 29/12/2020?
And 29, this is the recent, my lordship. This is entirely a concocted, my lordship, because they, due to some differences, my lordship, my father is
that-
not accepting the marriage, my
Case
lordship.
diary would be required.
My lord, I am 21 years old and nothing, my lordship.
No
Due to
accusation.
differences between my parents, my lordship,
Heard Mr. S.B. Laskar, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned the additional public prosecutor. Considering the nature of accusation made against the present petitioner in the FIR, perusal of the case diary would be necessary. When?
Notice should be also there, POXO.
she is
21.
She's almost 18 years old, my lordship.
Also issue note, since the offense under POXO Act is involved, issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 within 2 days from the date of this order, written as per the prevailing notification of the registry in this regard. Within 2 days from the date of this order, returnable on 21st of March. Also call for the case diary, list accordingly.
21st.
My lordship, there is much delay, my lordship. 10/1/2025, my lordship, FIR has been lodged and it is 29/12/2024, my lordship. Offense, my lordship. And age difference, my lordship, from
No, unless we peruse the
like,
clear
kindly see that
accusation.
the delay in lodging the FIR, my lordship, kindly see, my lordship.
No, that is not enough. We will see the case diary and thereafter consider your prayer.
Shorter date may be well, my lordship.
You have to take steps for issuance of notice. 21.
Earlier also rejected my page 10. The lawsuit order.
Once it was rejected,
After perusal of city, now I have come matter on the ground of negative and some other person is subsequently in another court. Same matter, same name accused. They got 3 arrest bail matter. So in our case, but I'm not saying that today you'll also consider, you'll also kindly call for the court. Subsequent, maybe some development may be there, matter. After 1 month, that consider page 2020, page 23. So at this stage, matter, I'm not asking anything more, matter.
heard Mr. H.R.A. Chaudhary. Investigation is still going on.
Yes.
H.R.A. Chaudhary, learned senior counsel, assisted by Mr. A.F.N.U. Molla, learned counsel for the petitioner, also heard Mr. K.K. Das. Since this application for anticipatory bail has been made by the petitioner for the second time, perusal of the case diary would be necessary, hence call for the same. Fixing
23.
23 for
20.
23. 203.
20.
Yes, 203.
Back to the. My lord, the petitioner before your lordship is a my lord Jala Parishad member. And FIR, my lord, at page 14. The 11th portion. Here, my lord, one accident took place on my lord 6/2/2025. My lord, kindly I may be allowed to read out the FIR, my lord. I have the,
No, you first tell me your case.
my lord,
What?
case is that, my lord, here, my lord, one, my lord, father, my lord, taking his son, my lord, from school, my lord. Then, my lord, at that time, my lord, one truck, my lord, due to the harsh and negligent driving, my lord. This father and son, my lord, killed in the accident, my lord.
Okay.
And my lord, obviously, my lord, this is a highway, my lord, and local people gathered there, my lord. And immediately, my lord, I have shown one, my lord, call record. People became, my lord, very emotional because, my lord, immediately after the incident, page 16, my lord, just
No, you tell me the story. What is your,
But immediately, my lord, the local police was called, my lord.
thereafter?
Thereafter, my lord, the local police reached to the, my lord, the spot, my lord, after almost 1 hour. But where, my lord, it is only, my lord, 3 to 5 minutes is required, my lord. Therefore, my lord, police, my lord, people became, my lord, emotional. And my lord, the argument started, my lord, with the police, my lord. Then petitioner was, my lord, local representative, panchayat representative, my lord. He came, my lord, along with SP, my lord. And he tried to, my lord, console the people, my lord. Nevertheless, my lord, some, my lord, the stone painting was also taken place as per allegation, my lord. And he used, my lord, gathering, my lord, 1,000, 2,000 people came on, my lord. But here, my lord, informant when lodged the FIR, my lord, he obviously, my lord, he is the outsider. He does not know, my lord, anybody's name, my lord. But when petitioner and another person was there, my lord, and in the FIR, it is alleged that, my lord, this, my lord, incident was provoked by the petitioner before your lordship. And 2 persons' name is mentioned, my lord, and 1 person's bail is already granted by the Planet Session Judge Hailakandi, my lord. And lordship, kindly have a look, last line, my lord, it is alleged, my lord, but here, my lord, one important aspect of this FIR is that, my lord, here admitted position of the fact is that, my lord, incident took place at, my lord, in the FIR, it is mentioned 12:10 PM, my lord. And, my lord, he got formal instruction on 1 PM, my lord. And, my lord, therefore, without any, my lord, medical treatment, my lord, local people, my lord, alleged that, my lord, had they were taken immediately to the hospital, then, my lord, they could have, my lord, saved, my lord. But due to, my lord, their negligence, 1 hour delay reaching in the spot, my lord, they killed, my lord.
What is your name?
My lord, his name, my lord, Soedul, and another person's name mentioned, my lord, in the FIR last part, Johirul. And Johirul was already granted bail by the Planet Session Judge, my lord.
Where is the bail order?
My lord, page 20, my lord.
And what happened to you?
My lord, he also preferred bail, my lord, application, but there was 2 court, my lord, one additional and another session, my lord, and his bail was, my lord, declined by the session, my lord. And it was granted by the additional session judge.
On what ground he was granted bail? Because you are,
My lord, allegation is that, my lord, provoked, my lord, and admittedly, my lord, they were, my lord, one photograph I have also annexed, my lord, lordship, kindly have a look, he is on the side of, my lord, SP, my lord. Lordship, kindly have a look. Page, my lord, 19, my lord, annexure 5, my lord. This, my lord, black jacket with, my lord, the red sweater, he is the humble petitioner before your lordship, and left hand side, my lord, who is, my lord, Johirul got bail, my lord. They are, my lord, a local, my lord, politician. So obviously, my lord, they came, my lord. Only, my lord, he knows, my lord, their name, my lord. There were put formal name there, my lord. But allegation is that, my lord, they, my lord, provoked, my lord. But lordship, kindly imagine, my lord, on the spot, my lord, father and son, my lord, lordship, kindly have a look, photograph I have also given, page 15, annexure 2. Lordship, kindly imagine this person spot dead, my lord, and police went there after 1 hour. So what would be the, my lord, the emotional, my lord, situation of the public, my lord?
but you provoked.
No, my lord, how it is provoked? Lordship, kindly look, he is, my lord, how, my lord, gently he is trying to control, my lord, people, my lord, page 19, my lord. He, my lord, educated, my lord, leader of the local, my lord, how he cannot, my lord.
Yes, Mr.
Yes, Lordship. Out of the many sections, there is 121 and 132. 121 is the voluntary causing hurt or grievous hurt to deter public servant from his duty. And second, 132 is, Lordship, assault or criminal force to deter public servant from discharge of his duty, Lordship.
Yes, no accusation against him is of provocation, provoking the public.
And his name is also there, Lordship.
And my lord, in the FIR, it is clearly stated that, my lord, from the crowd, my lord, 1 stone came, my lord. And he was along with them, my lord.
So, Lordship, there are many people are involved here. So only looking into the CD, it can be ascertained whose role is what,
So, my
Lordship.
lord, I am, my lord, on, my
Because
lord.
many people, unlawful assembly is there, so many people are involved, Lordship.
Where is your rejection order?
Well, rejection order, my lord, I have not got, my lord.
Why?
Well, after some time, my lord,
Then you file rejection order.
well, after some yet two, my lord, kindly I will allow.
No, bring the rejection order on record. That is the requirement. Your prayer was rejected by additional session judge,
Session judge.
session judge. That rejection order has to be there on record. You file it formally. When? Tomorrow? Or on Monday?
Well, I will bring, my lord, tomorrow, my lord, tomorrow maybe fixed, my lord, matter.
Heard Mr. A.M. Burguia, learned counsel for the petitioner, who prays for some time on Monday.
My lord, kindly, my lord, some urgency, my lord. His mother is also ailing, my lord. Tomorrow, my lord, I will
Who
file.
prays for allowing the petitioner to file an additional affidavit for bringing on record the rejection order of bail of the petitioner by the sessions judge. Hailakandi. The prayer is allowed. Let this matter be listed again tomorrow, that is on 13th March.
Skip number. May I please, boss?
And this case, lordship, my lord, the FIR lodged against the petitioner's lordship on malicious, my lord. Malicious lordship and the POCSO is, my lord, totally, my lord, misused in this case. Several litigations are, my lord, pending before this, before the civil court, my lord, learned magistrate lordship. And charge sheet was given against, submitted against them, lordship. Trial is going on, lordship. And FIR, further FIR was lodged against them, lordship. My lord, but the present informant lordship has, my lord, filed a, my lord, complaint case before the learned magistrate lordship, my lord, after 16 days, 11 days, lordship. Thereafter, my lord, after 1 month, my lord, case was forwarded to the OC lordship. Now kindly see the FIR at page 12, lordship. This is long FIR drafted by the learned, my lord, lawyer lordship and submitted before the learned magistrate lordship. And the learned magistrate has forwarded to the OC lordship for registering a case lordship. My lord, this is a.
Case diary would be required.
Now, my lord, for my lord. Yes, your lordship will call, may call the case. Now, my lord, for a timing lordship. Kindly see lordship, page 21. Page 21, this is a FIR lordship. My lord, wife of the petition number, my lord, 1, Safiqul Islam, lost FIR, my lord. This is in 2019. In that case, my lord, accused is, my lord, Sabiqun Neha, my lord, in that case, present FIR lordship, she is, my lord, accused lordship. My lord, kindly see, in that case, charge sheet was submitted lordship, and the trial is going on lordship. The kindly see the paragraph to page 24 is the status of the case lordship. In evidence stage lordship. Now, page 24, kindly see. My lord, date is fixed on, my lord, that is in still going on lordship. Now, my lord, she was, my lord, the petitioner's wife was beaten, kindly see, page 25 lordship. How, my lord, he was beaten lordship. In that case, my lord, trial is going on lordship. Now the status, daily status of the case, again, my lord, title suit lordship. Kindly see lordship, title suit injunction case is at page 28 lordship. In that case, my lord, we are the defendant lordship. We are the defendant lordship. That is also pending lordship. Now kindly see lordship, last FIR lordship at page 16, page 32 lordship. What was the actual fact, my lord? Page 32 on the day of alleged incident lordship. 5/1/2025 lordship. It was happened lordship. Immediately, my lord, we lost FIR lordship. In that FIR, my lord, the police did not register. My lord, nowadays, my lord, this is trend of the, my lord, in the police station lordship. As my lord, cases are not registered in, my lord, some cases lordship. Now that is pending before the, my lord, IO. Now, my lord, the incident was, my lord, exactly on that, my lord, on 4/1/2025 lordship. My lord, the alleged offense is lordship on 5/1, my lord, in the, my lord, Kindly see, Lordship, this is the page 32. This is exact fact was incident was happened on that very day, Lordship.
No, what has happened? You have to tell.
My lord, kindly see, Lordship. My lord, the petitioners, my lord, land was, my lord, encroached over, Lordship, and that.
So there is a land dispute.
My land dispute, Lordship. Land dispute is going long. My lord, petitioner's wife of the petition number 1 was beaten, Lordship. Charge sheet was submitted. Trial is going on
No,
against them.
that is a matter of 2019.
Now present in 2005 also.
You cannot bring a 2019 incident.
My lord,
in
on the alleged incident, Lordship, FIR was also lodged by the petitioner's wife, Lordship. This is page 32, Lordship. My lord, against this FIR, Lordship, the POCSO is misused, Lordship. My lord, the kindly see the language of the FIR complaint lodged against the petitioner's, Lordship. What is the language, Lordship? My lord, it was drafted by my lord, expert hand, Lordship. Now page 32, this was happened, Lordship. My lord, absolutely, this is a malicious affair, Lordship, lodged against the petitioner's, Lordship. My lord, this was happened, this affair was lodged on 5/1/2025. My lord, kindly see their affair, Lordship. What was their affair? Kindly press, but to page 12, Lordship, kindly come back, page 12, Lordship. Page 12, my lord.
This affair has not been registered.
Not registered, Lord. I have stated in the, my lord, petition, Lordship. Now, vernacular exact, page 20.
What is the accusation against you? What has been alleged?
Against us, Lordship.
Yes.
My lord, kindly see the at page 12, Lordship. This is the FIR translated copy, vernacular, you, Lordship, kindly see vernacular, Lordship. This is the complaint, format of complaint, Lordship. Page 7.
What is the accusation against you under BNS?
Under BNS, Lordship, 318 Lordship, sitting Lordship.
318?
Lordship. Cheating.
Then why have you mentioned 63 and 65?
It is the Copyright Act, Lordship.
Oh, copyright.
51, 65, Copyright Act, Lordship.
Okay, okay.
Copyright Act, Lordship.
318 relates to breach of trust. What is the offense? 318?
Offense, Lordship, it's the Century Plywood, the Lordship, large producer of plywood, Lordship. Their allegation is that, Lordship,
Where is
they-
the FIR?
the page 13, Lordship, they have received, Lordship, the copyright over, Lordship, GLP word, Lordship, and their artistic word, Lordship. And they have alleged that, Lordship, the petitioner is using that word GLP in the artistic word, Lordship. But things that, Lordship, the petitioner is not even using this. Lordship,
Whether
artistic
this
word, Lordship.
Copyright Act 63, 65, 51 are penal provisions.
Yes, Lordship.
Penalty has been prescribed.
Yes, Lordship.
How much?
Lordship, in 63, Lordship, it is, Lordship, up to 3 years, Lordship.
Okay,
And 65, Lordship, up to 2 years.
so 2 years.
Up to 2 years. But
51?
63, 51, Lordship, means when copyright is infringed, Lordship, this is explanation, Lordship, but no.
It is not a penal provision.
Yes, Lordship.
And what is 318 punishment?
63, Lordship. 318, Lordship, up to 3 years, Lordship, sitting.
Okay, now what is your case?
Lordship, the informant of the file is apparent, Lordship, alleging that, Lordship, they have received copyright over, Lordship, GLP word, Lordship. It is mentioned in paragraph 14, Lordship, page 14, Lordship, in second paragraph. Page 14, second paragraph. In the FIR.
Okay.
Lordship, may I, Lordship, we state that the supplier.
Oh,
is
okay.
distributing-
Copyright, they had the copyright of the, what is GLP?
GLP, Lordship. They
Okay,
are saying that, Lordship, they have. received
this has
copyright
been
over-
violated
Yes, Lordship.
by you.
Yes, they are saying is that we are using that GLP, they are artistic word, Lordship, but it is not that, Lordship. We are not using that, they are artistic word, Lordship. This is something different, Lordship. I have some photograph, Lordship. The first one, Lordship, our brand, Lordship, Canon Club Prime, Lordship. We are using GLP, that one, Lordship. Below one, Lordship. The petitioner brand is Canon Club Prime. And next one, Lordship, the Century Ply, Lordship.
They have their artistic word GLP does something different words. Second case also. And they have their lordship GLP lordship, that is blue line protection. They are lordship, they are GLP lordship, but our GLP is lordship. Good laboratory practices lordship. We have annex lordship and it is a page 22 lordship.
Where have you mentioned?
Page 22 of our petition lordship. Good laboratory practices, lordship. GLP stands for.
Ah.
And the artistic work also something different lordship, not similar to their GLP lordship.
Okay. Yes, Mr. Das.
The name is same, lordship, GLP,
GLP lordship, but artistic work is
Heard
different. lordship.
Mr. A. Nath,
different.
learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioner Bhagwati Prasad Harlalka, who is apprehending his arrest in connection with Gorsuk PS case number 54/2025 under section 318 BA of BNS, read with section 63/65/51 of Copyrights Act 1957. The gist of accusation in this case is that on which date it has been filed? On date of FIR is
That is, that of FIR is 3/2025 lordship. Registered on lordship 17 February lordship.
on 3/2/2025. One, Shri Chetna Khanna, Mrs. Chetna Khanna had lodged an FIR before the officer in charge of which police station? Gorsuk police station, inter alia, alleging that the petitioner company is cheating general public by using false trademark and by infringing the copyright of the first informant in respect of renowned within inverted comma GLP stop. Learned counsel for the petitioner has submitted that the petitioner has, your company deals with
Lordship and plywood lordship. Plywood and block lords.
you are proprietor of which company?
Operator of lordship, North Bengal Industries.
The petitioner is the proprietor of North Bengal Industries, which deals with manufacture of plywood, plywoods. And they have not in any manner violated the copyright of the first informant, as the artistic work GLP used by the petitioner in the plywoods manufactured by them carries a different meaning, that is that is within, that is good laboratory practices and the in the design used by the petitioner in their, in the plywoods dealt with, manufactured by them is different from the design on which the informant is claiming the copyright. Stop. The petitioner submits that learned counsel for the petitioner submits that the petitioner is ready to cooperate in the investigation, and considering the nature of accusation made in this case, his custodial detention may not be necessary. On the other hand, learned additional case diary would be required. Learned additional public prosecutor has submitted that case diary may be called for. Stop. Issue call for the case diary. Fixing 27 3 for case diary. Stop. In the meanwhile, considering the nature of accusation made in the FIR, as well as submissions made by learned counsel for the petitioner, this court is of considered opinion that before arrival of the case diary, if the petitioner operates in the investigation, his custodial detention may not be necessary. Hence, hence the above named petitioner is directed to appear before the investigating officer of Gorsuk PS case number 54/2025 within a period of 7 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest in connection with the above noted case, in connection with the Gorsuk PS case number 54/2025, he shall be allowed to go on interim bail of ₹30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. List accordingly on 27/3.
May I also date is 28 lordship. On 27 and
List on 28. What is going on?
Item 41 of supplementary list.
Make clear, Lordship. There's a 428 application, my lord.
41.
41 supplementary. My lord, here, my lord, charge sheet has been filed, my lord, showing the petitioner as an absconder, my lord. And the allegation against the petitioner is that, my lord, I have raped a girl, my lord, who is below, my lord, 18 years of age, my lord. Now your lordship will turn to page 13 for a once, my lord. 1-3. My lord, the form, my lord, lordship will see, my lord, the FIR was lodged first line, my lord. FIR number so and so, filed on, my lord, 9/8/21, my lord. And
Page
below,
number? Page number?
page number 13, my lord, 1-3. The form of the FIR, my lord. Our part.
Yes.
My lord, first line, my lord, Jalukbari, year FIR number, date, my lord, 9/8/21, my lord. This is the date of lodging of the FIR, my lord. And below, my lord, your lordship will see, my lord, the column C, my lord, information, sorry, my lord, B, my lord, occurrence of offense day, my lord, date 25/2/21. So after 6 months, this FIR has been filed, my lord. Now, my lord, in the instant case, my lord, the police after investigation has filed a charge sheet, my lord, showing the petitioner as an absconder, my lord. Now your lordship will see, my lord, the last page, my lord, page 24, my lord. Page 24, my lord.
Yes.
This is the birth certificate of the petitioner, my lord, where your lordship will see, my lord, his date of birth, my lord. Date of birth, my lord, 1/1/2004, my lord. 1/1/2004. Lordship found it, my lord.
Whose date of birth?
My lord, the petitioner, my lord, Manzoor Alam. Name Manzoor Alam. Date of birth 01/01/2004, my lord.
Yes.
Now, my lord, assuming, my lord, but not admitting the offense, my lord, the allegation, my lord. On the date of occurrence of the offense, my lord, the petitioner was a minor, my lord. His age was, my lord, 17 years, 1 month, my lord, on that date.
Okay.
Now, can I be tried, my lord, under this this section, my lord, now, my lord? Because on the date of occurrence, I was a minor.
Have you raised this plea before the trial?
My lord, now only someone has been issued, my lord.
You appear before the court
And
and
I will appear before the court, my lord, some protection, my lord.
what protection?
My lord, otherwise on the first day, if I appear, my lord, I may be put behind the bars also, my lord.
No, what protection you want?
My lord, in fact, my lord, this application, my lord, I filed this application, my lord, under section 528 of the BNSS, my lord, read with section 483 of the BNSS, my lord.
483.
Yes,
483 is applicable only when you are
apprehending arrest.
No, 483 is you have to be in custody for applying 483.
So that in that case, one not may give, my lord, no coercive action may be taken, my lord. I will appear.
No,
before.
483 does not lie now. It is premature.
May-
483 would be applicable only if when you are in. You are not in custody.
No, my lord, I'm not in custody, my lord.
Then whether 483 is applicable, that too before this court.
But he has wrongly, it would have been, my lord, 482, my lord. 482 will
482 also may not be
But
maintainable.
so in that case, my lord, I pray before your lordship, my lord, the no coercive action, my lord, I'll appear before the court.
No, how we can
But
that?
or your lordship may direct the court below to consider the bail, my lord, that much.
No, that is also not required. If you file an application, it will consider.
That if your lordship, my lord, reflects in your order, my lord, my submission, my lord, that he was a minor, my lord, at that point of time.
You can take this plea before the trial court.
Yes, my lord, that we can, but
by making that observation, because 483 is not maintainable.
yes, my lord.
No other relief can be granted at.
Yes, my lord, that's true, my lord. But if I appear, my lord, the court may put me behind the bars also.
No,
But
that on that apprehension, court may grant you bail also.
may what is that, my lord? May also, my lord. May also.
You don't have a case. Heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 528 of BNSS, read with section 483 of BNSS 2023 and article 227 of the Constitution of India has been filed by the petitioner praying for what relief you are seeking?
My lord, quashing of the
Praying
charge
for
sheet.
quashing of the charge sheet. Quashing of the charge sheet number 360. Quashing of the charge sheet filed against the petitioner before the Court of London. Special judge in special case number 294/2024. London Stop. Learned counsel for the petitioner has submitted that on the basis of an FIR which was lodged on 9/8/2021 against the petitioner and a charge sheet was laid before the Court of Learned Special Judge POCSO under section 376(2)(1) of IPC, read with section 4 of the POCSO Act, read with section 9/10/11 of the Prohibition of Child Marriage Act. Stop. The said case was registered as Sessions Special Case number 294/2024 and is presently pending before the Court of Learned Special Judge POCSO, Kamrup Metro, Guwahati. Learned counsel for the petitioner has submitted that the petitioner has received summons from the trial court. However, he submits that on the date of alleged offense, he submits that even if admitting for the argument's sake the allegations leveled against the petitioner in the charge sheet, on the date of offense, the petitioner was a minor, as his date of birth is 1/1/2004, and the alleged offense was committed on 25/2/2021. Stop. Learned counsel for the petitioner submits that the petitioner was of 17 was
Moreover,
Compared to the investigation, madam.
Moreover, Lordship, 61 way, that is criminal conspiracy is also added here, Lordship. Moreover, Lordship, he has not complained to the bank account or FIR has not been lodged. That moreover, account, he has not given any valid, Lordship, source from how he has got, Lordship. He should have filed FIR if he is an innocent, Lordship. Why have not
no,
done
he's
this?
not
Lordship?
claiming to be innocent.
He is not an innocent in that sense.
I am in custody for the last 10 days. They have taken him into custody.
He should have informed.
These are all documentary evidence.
No,
Cannot be taken away.
whether his
This is an
the
economic offense,
interrogation is
Lordship.
maybe
Under custody.
interrogation is necessary or not.
Interrogation is necessary because many other people are there. Multiple complaints are there, Lordship, not only one.
10 days they have
Against
taken
this
it.
person.
And I am class 27. I am behind.
From different states, Lordship.
Put me under strict condition, madam.
You give me the case.
Lordship,
title.
Lordship.
Heard Mr. S. Vora, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, Shri Manoj Das, who has been detained behind the bars since 13/2/2025 within bracket for last 27 days in connection with Pathshala PS case number 12/2025 under section 318 within bracket 3, 318 within bracket 4, 61 within bracket 2A, 112/56 of BNS, read with section 66 within bracket B, 66 within bracket C, and 66 within bracket A of the IT Act. The gist of acquisition in this case is that on 12/2/2025, Vishnu Prasad Bhuya had lodged an FIR. Where is the FIR?
Lordship will page number 10 is the initial FIR, madam. This is by the bank. After investigation, police incident report. Page 10 is the FIR.
Lodged an FIR inter alia alleging that an inquiry was conducted in respect of suspicious transaction in the overdraft account of Messrs. Furniture House and of which the present petitioner is the proprietor. You are Manoj Das,
One of them.
present petitioner is the proprietor. It was found during inquiry that within the period 16/1/2025 to 21/1/2025, total 8,256 transactions were made in the said account. And an amount of rupees 73.45 lakhs were transacted. And the petitioner failed to provide valid source of the funds for these transactions. It is alleged in the affair that the petitioner had facilitated various transactions linked to cybercrime activities, and he allowed his bank account for facilitating illegal financial transaction connected with cybercrime and financial fraud stuff. Learned counsel for the petitioner has submitted that the only accusation against the petitioner is that he allowed his current account for parking of funds from unknown sources. From
One Moidul Islam. Means amount, my lord. This is all Moidul Islam has done it, my lord. Only the petitioner's account has been used.
parking of funds deposited to his account by one Masjidul Islam. He submits that the petitioner has been detained behind the bars for last 27 days, and in view of the period of detention, he may be allowed, period of detention already undergone, he may be allowed to go on bail. On the other hand, learned additional public prosecutor, Mr. K.K. Das, has produced the case diary of Pathshala PS case number 25/12/25 and has submitted that and has vehemently opposed the grant of bail to the present petitioner. He has submitted that there are materials in the case diary which shows the connivance of the present petitioner in the financial in the illegal financial transaction for defrauding the general public stuff. I have considered the submissions made by learned counsel for the petitioner as well as learned counsel for both the sides and have gone through the case diary. I will go through the case diary in chamber and pass orders in chamber.
Also taking account the custodial detention length,
Okay.
as well as the 10 days in custody of the
Of police.
police, my lord. 10 days I was taken into custody. Police was taken into custody. Thereafter, I'm in judicial custody.
Dot. Could you half second? I'm taking a short break. Received. Has he appeared?
Yes, he appeared, Madam, statement recorded, Madam.
None has appeared for,
Also, Madam, the item which was recovered from him, Madam, it was also given Zimma to him, Madam.
None has appeared for the petitioner or call. Learned additional public prosecutor, Mr. R.J. Barua, has produced the case diary and has submitted that the petitioner has appeared before the investigating officer and his statement has also been recorded. So, in view of the submissions made by Learned additional public prosecutor, the interim anticipatory bail granted to the petitioner by order dated 2/12/2024 is hereby made absolute, with condition number 3 attached to the said order remaining intact. With above observation, this bail application is disposed of. Send back the case diary.
May I please your lordships. In this case, my lord, respondent service complete, my lord, respondent also appeared, my sir. In this case, my lord, kindly have a look at page, my lord, 8, my lord, it's FIR, my lord. In this case, my lord, I am for the accused number 2 and 3, my lord. I am not for the prime accused. That's because, my lord, the accused number 1, who has already been held as, my lord, juvenile, my lord, by the learned JGB. It will also. And the present petition
He
was,
is
my
the
lord,
prime accused. Accused.
for the accused number 2 and 3, my lord.
Who are 2 and 3?
2 and 3, the maternal uncles of the accused number 1, my lord.
Okay.
Actually, what happened on that day, my lord, while the, my lord, at the backward, my lord, the petitioners, my lord, as well the accused number 1, my lord, and the informant victim, all are the, my lord, nearest neighbors, my lord. And there were some mobile talks in between the, my lord, accused number 1, that is Mokibul Haq, my lord, and the LS victim girl, my lord. And thereafter, my lord, some sorts of love affairs, my lord, developed in between them, my lord. And on the LSD of incident, my lord, there were some talks in between, my lord. They were talking something backward, at the backward of the house of the informant, my lord. Backward of the house of the informant, my lord. At that moment, my lord, there was some, my lord, hue and cry, and thereafter the present petitioners, my lord, who are the maternal uncles of the accused number 1, came to the place of occurrence and brought back the, my lord, accused number 1 to their own house, my lord. And thereafter, my lord, a village mail took place on that very night, my lord. And on that very night, my lord, there was no any fruitful discussion, my lord. And on that grudge, my lord, the informant has lost the affair, my lord, on the basis of only hearsay evidence, my lord. On the basis of hearsay.
Yes, Mr.
And accordingly, my lord, already, my lord, the respondent number 2, my lord, that is informant, they have filed affidavit, my lord, in this case, that they have no any objection, my lord.
And for respondent number 2.
My lord, we have put the case diary, my lord, what it is statement of the victim girl recorded, my lord. The main allegation is against my lord Mokibul, my lord, who has committed rape, my lord. But this accused person, my lord, the victim has saw, my lord, this accused person were also studying, my lord, nearby, my lord. This is the allegation. Otherwise, my lord, other allegations are not there, my lord.
Heard Mr. S. Ahmed, learned counsel for the petitioner. Also heard Mr. R.J. Barua, learned additional public prosecutor, as well as Mr. What is your name? Tiyuddin, learned counsel appearing for respondent number 2. This application under section 482 of BNSS has been filed by the petitioners Hannan Ali and Babul Ali, who are apprehending their arrest in connection with Boko PS case number 479/2024 under section 65 within bracket 1/49 of BNS read with section 4 of POXO Act. The accusation in this case is that the father of the victim girl had lodged an FIR on 1/11/2024 and alleging that the accused number one named in the FIR, namely Mokibul Haq, has committed rape on her minor daughter with the help of the present petitioners. Stop. Learned counsel for the petitioner has submitted that the allegation against the petitioners in the FIR are not true. He submits that the main accused, Mokibul Haq, has been declared as a juvenile and his case is referred to Juvenile Justice Board. He further submits that the present petitioners are the maternal uncle of the accused person, juvenile accused, maternal uncle of the delinquent juvenile. And when they saw their nephew with the victim girl, they only recovered the victim girl from the place and have not done anything else. Stop. Additional public prosecutor has produced the case diary of Boko PS case number 479/2024 and has submitted that the statement of the victim girl has been recorded under section 183 of BNSS, and in her statement she has implicated the main accused, Mokibul Haq, of committing rape on her. She has not stated anything against the present petitioner except the fact that they were standing near the place where the offense occurred. Stop. On the other hand, learned counsel for the respondent number 2 submitted that the respondent number 2 has no objection if the present petitioners are allowed to go on bail. Stop. Considering the fact, I have considered the submissions made by learned counsel for the parties and have gone through the case diary of Boko PS case number 479/2024. It appears, considering the materials in the case diary, it appears that the petitioners are not directly involved in the offense which has been alleged in the FIR, and therefore their custodial detention may not be necessary if they cooperate in the investigation. Stop. In view of above, this anticipated bail application is disposed of with a direction to the above named petitioners to appear before the investigating officer of Boko PS case number 479/2024 within a period of 7 days from the date of this FIR, this order, and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with Boko PS case number 479/24, the above named petitioners shall be allowed to go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Send back the case diary. This anticipatory bail application is accordingly disposed of.
Obliged, my lord. Much obliged. May please, your lordship. Lordship, 482 bail application, lordship. Lordship, case diary was called for. Item number 32, my lord, we have received the case diary, my lord. As party, my lord, ordered at 17/2/2025, my lord. They were granted interim protection, my lord. So, my lord, their statement not in the case diary, my lord. Lordship, so whether they have appeared or not, my lord.
Have you appeared?
Lordship, although the
Lordship had directed to appear within the 7 days, Lordship, but due to some medical condition, the petitioners could not appear on time, Lordship.
Then it will lapse.
After 7 days, they had not appeared, Lordship, because of the fear of apprehension, Lordship.
What is the submission?
Lordship, otherwise,
Then the interim goes automatically,
Automatically.
it gets vacated. Now it will be decided on merit.
Yes, merit, my lord, there are sufficient materials, my lord.
Lordship may kindly come to the FIR once, Lord.
No, why have you not appeared? You have not appeared.
Due to a medical condition, Lordship, the petitioners could not appear, Lordship.
Neither you have prayed for extension of time.
Yes.
Lordship may kindly grant us
303,
Yes.
some more time, Lordship.
what is the offense?
Offense, my lord, scope of vehicle was stolen, my lord. It was initially, it was hired, my lord. Later, my lord, they sold the vehicle to some other person, my lord.
That accused has been arrested, Lordship, not us, Lordship.
No, they are also
Not us.
involved, my lord. It's a gang of, my lord,
No,
6 persons.
Then I am rejecting the plea. There
Lordship-
are materials in the case.
There are materials.
Lordship, we.
There are materials, my lord, even there are objections from the investigating officer, my lord.
Lordship, kindly hear me once, Lordship. Lordship, we are the owner of a second-hand vehicle store, Lordship. Only we have been implicated, Lordship, because the police person, once the accused person who was arrested, Lordship, in this case, and from whom the vehicle has been recovered, he came to sell the vehicle to the petitioners, Lordship. And the petitioners have denied to purchase the vehicle because there were document lapse of the vehicle, Lordship. And we have denied purchasing the said vehicle, Lordship.
Whether
That is-
stolen vehicle was purchased.
No, my lord. Yes, my lord. Stolen vehicle, my lord. They took the vehicle on hire, my lord. Comment, my lord. My lord.
Not us,
Authorized,
Lordship, not
authorized,
us.
my lord, agent, my lord.
Huh.
Then, my lord, what happened, my lord? The person who have hired the vehicle, they sold the vehicle with the help of this accused person, my lord. In 7 lakhs rupees. Later on, vehicle was recovered, lord.
Vehicle was
Vehicle recovered later on, but that is different aspect of the matter. But vehicle was stolen, my lord. It was taken on hire, my lord, but they have not returned the vehicle, my lord.
It was
And they have sold to somebody
It was
else.
taken by one deposit Bora, Lord.
What is the allegation against them?
Against my lord, this Ongsuman Dotto, my lord. He is the person, my lord. He has arranged everything, my lord. Even the, my lord, parcels that he has arranged, my lord.
Lordship, we have annexed, Lordship, on page 13, Lordship. Already deposit Bora, who has taken the vehicle on hire basis, Lordship. From him, the vehicle has been recovered, Lordship. And we are a dealer of second-hand showroom, Lordship. And we have denied taking the vehicle from the same.
No, then we will go through the case diary. If there are materials against
ma'am.
you, then it will be rejected.
Lordship, may kindly allow us to depose our statement once, Lordship.
No, you have defaulted without any reason. Why this court should show leniency towards defaulters? You flag mark,
I have flagged it.
heard Mr.
D. Medila.
B.
D. Medila.
D. Medhi, learned counsel for the petitioner. Also heard Mr. R. Mr. R.J. Borua, learned additional public prosecutor. This application under section 482 of BNSS has been filed by the petitioners. Who are apprehending arrest in connection with Sibsagar PS case number 4/2025. The gist of accusation in this case is that on eight 1/2025, one Rajiv Kashyap had lodged an FIR before the officer in charge of Sibsagar police station, inter alia alleging that the informant is the proprietor of a car rental service named as within bracket advanced car rental service. And it has come to the notice of the informant that this vehicle was stolen,
Earlier, it was taken on rental basis, Lord.
that one vehicle, namely Mahindra Scorpio 511, bearing registration number AS01F K6879, was taken on rent by whom?
Lordship on deposit Bora, Lordship.
Taken on rent, and the
But it is not mentioned in the FIR.
not
Lordship.
mentioned. And the person who hired the vehicle was repeatedly disconnecting the GPS and deviated from the agreed route. It is also stated in the FIR that the vehicle was taken somewhere else without the knowledge of the first informant. And therefore, it was suspected that this said vehicle without the knowledge of the first informant, stop. On receipt of the said FIR, Sibsagar PS case number 204/25 was registered under section 303 within bracket 2 of BNSS. Learned counsel for the petitioner has submitted that though the petitioners were allowed to go on interim bail by order dated 17/2/2025, however, due to what?
Due to medical condition, they were out
Yeah.
of station. Lordship. They could not arrive on time.
Due to medical conditions, they could not appear before the investigating officer and defaulted in appearing before the investigating officer as direct within 7 days from the date of the order, interim bail order as directed by the court. It is also submitted by learned counsel for the petitioner that in the meanwhile, the vehicle in question has already been recovered and main accused has been arrested on
Yes, Lordship. On page 13, Lordship.
and the main accused has been arrested. He further submits that the petitioners are no way involved in the offense alleged in this case. In this case, and praise for allowing the petitioner to go on anticipatory bail. On the other hand, learned additional public prosecutor has opposed the
I
grant,
think, my lord, petitioner number 2, I am opposing, my lord. There number
Oppo-
1, my lord, there is no such
opposed
sufficient material.
the grant of bail to the petitioner number 2, namely Anshuman Datta, on the ground that there are sufficient incriminating materials against the said petitioner. However, as against petitioner number 1, he fairly submits that there are not much incriminating material justifying his custodial detention. Stop. I have considered the submissions made by learned counsel for the petitioners, counsel for the parties, and gone through the case diary of Sibsagar PS case number 4/2025. Stop. Since though the petitioner since after going through the case diary, it appears that against petitioner number 1, namely Vishwajit Phukon, there are not much incriminating material in the case diary, and his custodial detention may not be necessary. Hence, he is allowed to go on. His prayer for anticipatory bail is allowed. The petitioner, the said petitioner, within bracket Vishwajit Phukon, is allowed to, is directed to appear before the investigating officer of Sibsagar PS case number 4 4/2025 within a period of 7 days from the date of this order, and to cooperate in the investigation. If he does so within the stipulated period of time, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to satisfaction of the arresting authority with following conditions. Condition number 1 and 2. As regards petitioner number 2 is concerned, it appears that though he was granted interim anticipatory bail on 17/2/2025, however, he has defaulted in appearing before the investigating officer and has failed to comply with the directions of this court. Stop. Though learned counsel for the petitioner has submitted that the petitioner could not appear before the investigating officer due to medical conditions. However, no documents have been furnished to substantiate the said submission. Moreover, there are sufficient incriminating materials against the petitioner number 2. No. In record. Yes.
As the vehicle has already been recovered, Lordship, and there's no requirement of the custodial interrogation.
The prayer for anticipatory bail of the petitioner Anshuman Datta is hereby rejected. If police don't arrest you, then you will be, police may not arrest you.
Fact is that, my lord, there are several other cases are pending, my lord. That is why they are not appearing, my lord.
So 1 is granted, 2 is rejected.
Obliged, Lordship.
Wait, please, your lordship. Is that I am on interim, my lord, in this case. I appeared, my lord, before that.
Why you were granted interim bail?
As because, my lord, I am a owner of a, my lord, pharmaceutical shop, my lord. And one of my employee was arrested in connection to a case, my lord, NDPS case, my lord. That the employee is, my lord, Hafiz.
Yeah.
Hafiz
Yes,
Biam.
Mr. Das.
My lord, case there is received, Lord. He has appeared before the Lord investigating officer. His statements are recorded. Now he is only relation is not this name accused number 5. at the Milord FIR, Hafizul Mian, he was employee of this petitioner. Now, I have examined his statement also, Milord, he has been arrested. He has not implicated him, Milord, that either he has
Hafizul has not
not
implicated.
implicated him.
Okay.
And the Milord, contraband was seized from Milord, this accused number 1, Tuzammil Haq, from his possession. And on the basis of his statements, Milord, other accused persons were arrested who are involved.
So nobody has implicated. the
Now, so
present.
far, this statement of Milord Tuzammil, from whom this contraband was seized, he says this Hafizul used to supply them for selling in
He
retail.
has
Milord.
implicated Hafizul on.
He has implicated Hafizul,
Hafizul has not implicated the present petition.
present petitioner, Milord.
Okay.
But he is an employee of Milord, this present.
Okay,
petitioner.
heard Mr. N.J. Datta, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. Learned counsel for the petitioner has submitted that the petitioner was granted interim anticipatory bail on 20/2/2025. And in pursuant to the directions of this court, he has appeared before the investigating officer and has cooperated in the investigation. So on the other hand, learned additional public prosecutor, Mr. D. Das, has produced the case diary of South Salmara PS case number 4/2025 and has submitted that the petitioner has appeared before the investigating officer and his statement under section 180 of BNSS has also been recorded. He also submits that in the statement of the main accused, one of the main accused, namely Hafizul
Hafizul, yeah,
Mia, is the employee of the present petitioner and whose statements are also recorded. However, he has not implicated the present petitioner during his statement, in his statement. The learned additional public prosecutor submits that at this stage, there are no incriminating material against the present petitioner in the case diary. In view of the submissions made by learned counsel for the petition, learned counsel for the parties, and also in view of the fact that the petitioner has complied with the directions of this court and has cooperated in the investigation, the interim anticipatory bail granted to the petitioner by order dated 20/2/2025 is hereby made absolute, with condition number 2 attached to the said order remaining intact. This anticipatory bail application is accordingly disposed of. Send back the case diary.
Case diary is there. Office no process, চাইছিলো জানো জুনিয়ৰে কিবা এটা অফিচ নোট আছে বুলি দেখিছে ইয়াতে
POCSO, private, POCSO is there, my lord.
Milord, we are appearing, Milord, on behalf of the opposite party number 2. Now, we need, Milord, short time to file an objection, Milord, regarding this. Because earlier bail petition was rejected, that has not been placed on record, as the lordship will see from the statement. That has not been, Milord, made annexure.
What high court provision is it?
Para 6. There was an earlier rejection order also. And Milord, para 8 lordship will find there is a.
Okay, let him file objection.
Yes.
Let him file.
Well, not that matter, let it, I have told you.
Heard Mr. H.R.A. Chaudhary, learned senior counsel, assisted by Miss A.H. Ahmed, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, as well as Mr.
MU Mundal.
M.U. Mandal, learned counsel appearing for respondent number 2, who submits that as he has been engaged by the petitioner, by the respondent number 2 today only, he needs some time to file a written objection against the prayer for bail made by the petitioner. The prayer is allowed. let this case be listed. How much time?
17, my lord, he has given.
17.
Monday.
Let this case be listed again on 17th of March before the petitioner, the respondent number 2 shall file his written objection on or before the said date.
On or before, there will be vacation. Can it be on 18, my lord? So that we can file it on 17.
On 18. Instead of 17,
Yes, sir.
18.
Oblige, rules.
Item 42 and 43 from supplementary.
I am for 43, my lord, 42. Your lordship will find that
43.
page 43, both 43 may be taken first, my lord. He's a teacher, my lord, and actually in school, Gunashow was going on. And headmaster asked the teacher to bring the student from the house, they are going to spend money residences, my lord. According the petitioner has gone with his scooty and the victim was brought with his scooty. Now thereafter she made a allegation of minor sexual harassment. This is the case. You look at page 9, FIR is there. Yes.
Is it not permitted?
Heard Mr. J. Ahmed, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned additional public prosecutor. This application under section 483 of BNSS has been filed by the petitioner, namely Marfuza Khatun, who has been detained behind the bars since 11/12/2024 within bracket for last 91 days in connection with what is the statutory period of detention
90 days.
in connection with Mayong TS case number 105/2024 under section 61 within bracket 1/142 of BNS read with section 6 of the POCSO Act 2012. Since the petitioner has completed statutory period of detention for which she would have been detained behind the bars, under section 187 of the 187 clause 2 of the BNSS, the petitioner is entitled to get bail. Stop. Hence, the above named petitioner is allowed to go on bail of rupees 30,000 with 170 lakh amount, subject to the satisfaction of learned Special Judge POCSO. Which court?
Morigao.
Morigao. With following conditions. Number 1 and 2. This bail application is accordingly disposed of.
Special Judge POCSO Morigao. Hello.
Item 9.
Yeah, please, your lordship. Here is a case where we have come before lordship under 528 for quashment of a particular order. Before going to that particular order, lordship, I just like to apprise this honorable court the factual basis of this case. What has happened, lordship? A complaint was filed against this petitioner under Negotiable Instrument Act. The petitioner, lordship, was a dealer of topsoil cement at Siliguri. Now, they filed a complaint case against us, and we have cross-examined that particular complainant. Lordship will kindly come to page number 73 first to show certain very interesting fact. Annexure 3. regarding this particular cross-examination that has actually happened. Now, Lordship knows very well that in a negotiable instrument act, there is 139, that is the presumption is always against the drawer. And that presumption is a rebutable presumption. That means I have to rebut that presumption to the extent that I have issued the check not in enforceability of my legally enforceable debt. So if I am able to do so, then Lordship, perhaps the court may acquit me. Now, what this court below has done, Lordship, I will show you, Lordship. Lordship, kindly come to page number 74, Lordship. I'm just reading 2-3 lines so that I'm not wasting the time of this honorable court. Lordship, kindly see, exhibit number 15 was deposited by clearing check on 9/10/15. Check number is 012184 in the year 2014. I was working in Topsam Cement. Exhibit A is the checklist. Now, what happened? When they appoint a dealer, they issue a checklist. For new dealership, Exhibit A1 is the signature of our employee. We do not enter into any agreement with the dealers at that time of dealership. Only checklist is provided to the dealers. Now, in this checklist, Lordship, in the check amount, in this check amount 012184, the check amount was mentioned as 1,20,000. That means it was clearly mentioned in the checklist that this check will be deposited only for to the extent of 1,20,000, not more than that. Now there was a rivalry in between us. I started taking cements from them because I am getting cement from other dealers at a less cost. Now what they did, Lordship will kindly see, they enhanced this amount. They enhanced the amount of 1,20,000 and made it 4,85,354 and deposited the check and got the check bounced. Now, Lordship, what has happened? We cross-examined. After we cross-examined, Lordship, we have shattered their evidence. And after we have shattered their evidence, Lordship, they file a petition. We demolish their evidence absolutely. They file a petition before the court below, praying before the court to bring new evidence and to show that there was an agreement. Lordship, already their own witnesses have come and said that there is no agreement. Now, Lordship, kindly comes to page number 96, Lordship. Page number 96. This is the impugned order by which I am aggrieved, Lordship. May I read it, Lordship?
Yes.
Page number 96, Lordship. Your Lordship has kindly got it, Lordship. In the instant case.
Yes.
In the instant case, the accused has given rebutable evidence through Exhibit A, which is a checklist. Evidence of DW1 states that the accused person entered into an agreement with the complainant via checklist Exhibit A. At a time of taking the dealership of the complainant company, the accused entered into an agreement with the complainant firm via checklist, that is Exhibit A. Defense has projected through DW1 that the check in question, Exhibit 15, was issued is a blank, along with another blank check. At a time of taking the dealership on 16/6/2014, Exhibit A checklist is that this blank check number 012184 blank letter is not valid without any handwriting. Blank check is valid for up to rupees 1,02,000. So Lordship can kindly get it. It is there in their checklist itself, 1,02,000. DW1 stated that the signature appearing on the invoices is not the signature of the accused person. The complainant side has admitted that the aforesaid rebutable apparently creates doubt. This is their admission, Lordship. Complainant themselves have admitted that we have rebuted the evidence. Complainant side also admitted that the aforesaid rebuttal apparently creates doubt that although the check in question, that is Exhibit 15, was issued by the accused person to the complainant, but the same was issued by the accused person to the complainant, but the same was issued in blank, and the accused person has authorized the complainant to use the check, but only for an amount not more than 1,02,000. Which means that the complainant has put an which means that the complainant put an unauthorized amount and misused the check. it is stated that it is also means that the check was not issued for discharge of liability to the accused to the tune of 4,85,354. They could not prove at all that I have taken goods worth 4,85,384. No evidence at all, Lordship. Only as alleged in the complaint, it appears that such rebuttal has created a doubt that the accused had issued the check bearing number 0012184 dated 9/10/2015 on 16/6/2014 for discharge of the future liability, but only to the extent of 1,02,000 only and not more than that. Situated thus, the legal presumption as that this is where my humble submission is this, that the court below has committed an error, Lordship. Situated thus, the legal presumption as admitted by the complainant goes away, and the onus shift to the complainant to prove the case as per the law. How, Lordship? Once I have rebuted their evidence, how can they again bring fresh evidence in order to fulfill their lacuna? So the court below, what court below has done, Lordship may kindly see, the complaint petition number 1250 has prayed to adduce evidence of Pawan Sharma and Birendra Singh to prove the checklist exhibit A is not
This
the
is a complaint case
It's a complaint case.
and the procedure is
Procedure is summary procedure, Lordship. Up till 2 years. Summary procedure, Lordship. Up till 2 years, not warrant procedure, because it's a negotiable instrument act, Lordship knows punishment is up till 2 years, Lordship.
okay.
So
So
in
the
that
procedure has to be according to BNSS
BNSS.
or CRPC.
Yeah.
Or
Okay,
some-
this case is going on before 1st of July. So it has to go on as per CRPC only.
CRPC.
Before 1st of July. It has been going on 2015 onwards, Lordship. Since 2015. And this development, very interestingly, Lordship, took place at a time of argument. When I have completed my argument, I have already completed my argument, they have completed their argument. Court below was pleased to put only one question to them, that they are bringing all computerized document, but there was no 65B certification. That was the only question by the court, that there is no 65B certification, you satisfy. After this development, they filed this petition. And Lordship, let me just read this part, Lordship will understand very interestingly. Complainant in petition number 1250 has prayed to adduce evidence of Pawan Sharma and Birendra Singh to prove that checklist exhibit A is not the original one. As such, the checklist is, if any, is meant for keeping the internal record of the firm. Whereas their own witness has said that there is no agreement. We do not enter into any agreement with the dealer. We simply provide the dealer a checklist. And the checklist that has been exhibited by us, Lordship, is an original checklist, getting their original signature. So now when I have rebuted the evidence, how the court below can allow the complainant to fulfill their lacuna, Lordship? At this stage, if this evidence is allowed, it will be fulfilling of the lacuna of their own case. If anything, they would have had, they could have bring earlier.
Where is the bar?
Lordship, bar is here in CRPC, Lordship, if I'm not wrong, Lordship. By my limited learning says, Lordship, that the list of the witnesses has to be there first and foremost. In the list of the witnesses, the name of these two persons is not appearing. There has to be a list of the witness. Secondly, Lordship, there is no pleading in the complaint regarding this exhibit A. And there is no pleading in the complaint regarding an agreement that has been executed. So now by adducing evidence, how they can go beyond their own pleading, Lordship? These are the two legal bar which to my limited learning is there, Lordship. And now my defense has been disclosed. I have disclosed my defense. My cross-examination is over. Argument is over. At this stage, at this belated stage, they have come out this petition, which has been very surprisingly allowed by the court below. And it was a very plain petition without quoting any section. Anyway, that may not be there. Section they may not quote. But when I have rebuted it, 139 say that if it is a rebutable evidence, then, Lordship, the benefit goes to the accused. And they themselves, they are saying that there is no agreement. Now from where this agreement suffices?
When is the next date fixed?
30 April, Lordship.
For?
For cross-examination of this gentleman, Pawan Sharma. And interestingly, Lordship, he has filed affidavit, and the affidavit is a replica of the earlier one. No change.
No, Pawan Sharma has already filed
I
affidavit.
already filed affidavit. Already filed affidavit on evidence, and the copy has been served upon us. And it's a replica. It's an absolute replica, no change at all.
Okay, then we will issue notice, giving an opportunity to the respondent, fixing a date before 30 April.
Lordship.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Ms. No other
Reasonable day,
state is
Lordship.
not.
Kindly stay the proceeding, Lordship.
No, we will fix it before your next date. This application under section 528 of BNSS has been filed by the petitioner, namely Messrs. Soma Ghosh and number 2 Srimati Soma Ghosh, impugning the order dated 5/9/2024, whereby the respondent was allowed to deduce additional evidence after closure of the evidence of the defense side when the case was fixed for argument.
Argument, at the argument stage, Lordship.
And stop. Issue notice to the respondent.
Court has allowed the complainant to give fresh evidence, Lordship.
Complain.
Yes, not the defendant, not to
Absolutely.
us. That is why I am
Can-
saying that court has done a big mistake.
To whom? Purapan. No, not respond. Respondent of this case. He is
Respondent of
the
this case. Is the
respondent of this case. Within bracket complainant in
CR case number.
CR case number
2822.
2802 was allowed to adduce evidence. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by registered post with AD as well as by usual mode within 3 days from the date of this order.
Can it be,
When-
Lordship, can it be at least 1 week because my client is
Within
staying.
7 days from the
7.
date of this order, returnable on, when is the next date fixed?
30 April, Lordship.
Returnable on 24th of April. List accordingly.
May I please, your Lordship? Your Lordship, here what has happened, it is absolutely a civil dispute. I will show your Lordship why I am saying it's a civil dispute. Lordship may first come to page number 51. Then I am coming to your Lordship, why it is a civil dispute. Global Industries, Lordship, is a industry which is situated, page number 51 if your Lordship can find it, Lordship.
Yes.
Global Industries, Lordship, is an industry situated at Noida, and they are manufacturing different machines. As per the terms and conditions of this Global Industries, Lordship, 75% advance has to be made at the time of the order and the balance before dispatch of the machine. Your Lordship has kindly got it, Lordship.
Okay.
Then Lordship may kindly see that the payment that has been made is not refundable. It's a very, number 14, Lordship, you see, it is very smallly written. I'm very sorry for that. It's not refundable. Number 18, Lordship may kindly see disputes are under Noida jurisdiction only. So when any dispute arises, it is under Noida jurisdiction. Now what has happened? The complainant, he from YouTube. Nothing has happened in Guwahati, Lordship may kindly see. From YouTube, he has seen our machine. And then he visits Noida. After visiting Noida, our office,
What machine you
he
manufacture?
dumpling making machine.
Dumpling means?
Momo
Okay, okay.
machine. Now, Lordship, he visits our factory at Noida, Lordship. And he looks into the demonstration of the machine. He places an order at Noida itself and he pays rupees 50,000. Whereas the cost of the machine is 1,90,000. He was supposed to pay 75,000. 75% he was supposed to pay. And then he has not made any payment. And without making any payment, Lordship, he has filed a complaint case against me here and a cognizance has been taken against him. Lordship may kindly see. It is absolutely a civil dispute. If something has to be done, machine is ready. I am ready to give the machine right now. If he pays the balance amount of money. His complaint, Lordship will find his complaint starting from annexure number 1, Lordship.
In the complaint, he has stated that he paid only 50,000.
Yes, Lordship. Paragraph number 4, Lordship. An advance amount of rupees 50,000 only. The IMS transaction, so and so, so and so, so and so. Whereas he was supposed to pay 75% of 1,90,000.
Heard,
He
Mr.
was, he was supposed to pay 1,42,500, Lordship.
Okay.
The civil dispute, Lordship, absolutely a civil dispute.
But
There's no criminality at all.
civil dispute may also give rise to a criminal offense.
Yes, yes. Lordship is absolutely correct. There is a silver line difference between civil dispute and
Yes.
criminal
Here,
dispute.
whether the ingredients of 420 are
Absolutely, Lordship. There is no ingredient of 420, Lordship.
Why?
Why I'm saying, Lordship, because first of all, I have not induced. He has visited. I have said that 75% you have to pay. 75% is 1,42,900, Lordship, because the machine cost is 1,90,000. Now he has simply paid 50,000 because this machine has to be manufactured by me by the third party, Lordship. How do I manufacture the machine if he does not pay me the 75%? And that is in the agreement itself, Lordship. He is aware about the agreement. This global interest agreement is here with him in page number 51. And this page number 51 has been annexed by him in his complaint.
It is annexed.
Yes,
Okay.
he is annexed. He is aware of it.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. State has not been made
No,
party.
Lordship, it's a complaint, private
PR
complaint,
case.
Lordship. PR case, Lordship.
Okay. State party. This application under section 528 of BNSS 2023 has been filed by the petitioner Shri Mukesh Kumar, praying for washing the proceedings of complaint case number CR case number 665/2023 pending before the Court of Learned Judicial Magistrate First Class, Kamrup Metro. Learned counsel for the petitioner has submitted that the respondent has filed a complaint case before the Learned Chief Judicial Magistrate Guwahati, which was registered as CR case number 665C 2023, wherein it was alleged that the respondent decided to proceed or purchase dumpling making machines from the petitioner's company and also paid an advance amount of rupees 50,000 towards the said purchase. However, in spite of the receipt of the advance amount, what is this 35,000?
Lordship, this contract says this 75% of the machine cost has to be paid, Lordship. that will be 1,42,500
Hmm.
in advance, so that the machine can be manufactured. And
However,
if,
same has not yet been delivered. The complainant has alleged that the complainant respondent has alleged that the petitioner is engaged in deceptive practices and has cheated the present petitioner. On filing of the complaint, the Court of London Judicial Magistrate First Class, Kamrup Metro, took cognizance of offence under section 420 of Indian Penal Code against the present petitioner and issued processes to the petitioner. Learned counsel for the petitioner has submitted that the dumpling machine which the respondent intended to purchase cost about
1,90,000 Lordship.
1,90,000. And as per the terms and conditions of the petitioner's company, it is required that the 75% of the value of the machine has to be paid in advance at the time of
Booking of this machine,
placing the orders.
Lordship.
However, in the instant case, no, the respondent has not paid 75% of the value of the machine which he had ordered. And therefore, the machine was not dispatched to him.
As per the terms and conditions of the agreement, Lordship.
As per the terms and conditions of the agreement. Learned counsel for the petitioner has also submitted that
No cause of action arose at Guwahati, Lordship.
no cause of action arose at Guwahati. Cause of action,
Because he has, Lordship, he has gone to Noida and he has made the order
where it has to be
uh,
delivered,
delivered Guwahati,
then there may be a cause of action.
delivered Guwahati.
Stop. Learned counsel for the petitioner has submitted that the dispute, if any, between the parties are purely
Civil in nature.
civil in nature, and this criminal case has been filed only with an intention to pressurize the present petitioner. He submits that no ingredient of section 420 of the Indian Penal Code is there in the averments made in the complaint by the respondent before the learned judicial magistrate first class. Stop. Issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondents by registered post with AD as well as by usual mode within 7 days from the date of this order. When is the next date?
Next. 24 March only, Lordship.
Returnable on 24th of April 2025.
24 March, this month itself, Lordship.
No, 24th of April 2025. Till as prima facie, it appears that the dispute between the parties, as prima facie, the dispute between the parties appears to be civil in nature. And after considering the submissions made by learned counsel for the petitioner, as well as going through the materials on record, the further proceeding of CR case number 665/2023 is
665.
stayed till next returnable date,
Deeply obliged, deeply obliged.
list accordingly.
What case there is there? You're nice, so
We'll fix it on Saturday, next Tuesday.
Lordship, after some time, maybe 5 minutes.
We'll put number 20.
We have to rise early today.
Lordship, within 5 minutes.
Okay, after some time.
After 5 minutes, because interim order is not there.
Okay.
It will go.
And we have received the case there.
Meet you, Your Lordship. So as per the last order, we had served copy on the standing council health department. Because they are the necessary party. This matter may come up for admission hearing.
Whether copies
Copy has been served, my lord.
served,
Copy has been served, my lord. Copy has been served to Mr. B. Gogol.
heard Mr. D.K. Bhattacharya, learned counsel for the petitioner. Also heard Mr. State PP.
Stays apart.
P.S. Lakar, learned additional public prosecutor. Learned counsel for the petitioner has submitted that as per the directions of this court, the petitioner has served the copies of notice as well as criminal petition to Mr. D. Gogoi,
Gogoi.
P. Gogoi, learned standing counsel, health department staff. Let this matter be,
Admission.
whether records would be required.
My lord, actually, there is no interim order in this matter. Trial is going on. We have annexed everything that was provided on, after our appearance. We have annexed everything.
Let this matter be listed for
Scan
admission.
call for. Scan copy will be called.
Scan. Let this scan copy of which case?
That's CR case number
Let this scan copy of CR case number
5275.
5275C slash 2017 be called for from the Court of Learned Chief Judicial Magistrate. Kamrup Metro. List this matter in admission column after receipt of the trial court record.
In this case, appeal has already been admitted, madam. Well, petitioner is, madam, the IA for, madam, bail. Petitioner for bail, madam. He is in jail since last 5.5 months. For conviction is 7 years, madam. Under section 370, subsection 2, IPC and 366. Well, I have annexed all the evidences. PW and my lord statement recorded at the 313. So, my lord, I am praying for my lord that consideration of his bail. My lord. Statement of witnesses, my lord, PW1 is the victim, my lord, alleged victim. Her statement is not corroborated even with the statement of informant and her husband and other witnesses, my lord.
No, we will not go into merit. Some materials are there against you.
Well, the
Victims.
Yes. Victim statement, my lord, who recovered the and allegedly informed to the other family members, those are not corroborated, my lord, in the. And she alleged some, my lord, some allegation brought
Yes,
some
Mr.
allegation.
Locker.
We couldn't go through the HCL also, that is why.
Then next week, my lord, if possible, my lord,
Both way. Okay, heard Mr. N.K. Kolita, learned counsel for the petitioner.
let him go.
Also heard
Lordship,
Mr.
LCA not receiving, LCA to hand.
P.S. Locker. P.S. Locker, learned additional public prosecutor. We'll fix date in the next week.
Yes, my lord.
The scan copy of the LCR, which was called for, has not been received. Issue reminder for the same. Let this matter be listed again on
19, my lord.
19 or week next after that. 25.
Well,
This matter on 25 March.
May I please your lordship? As per the last order, I have completed the service to the respondent authority. As per the office note, service report is awaited at lordship.
Yes, what is the submission?
Service report is there as per office.
We have to wait for some time.
Yes,
We'll wait.
Okay.
Heard Mr.
A. Burag,
A.
A. Buragoha.
A. Buragohai, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. As per the office note dated 10/3/2025, the notice issued to respondent number 2 has not yet returned. Await further. List this matter after 2 weeks on a date to be fixed by registry.
May I please, Your Lordship. Lordship, I will take a step by tomorrow, Your Honor.
Heard Mr. What is the name?
TT Moni.
TT Money, who prays for, who submitted, you have not taken steps. Who submits that due to some unavoidable reasons, the petitioner was unable to take steps for issuance of notice on the opposite party. As directed by this court by order dated 14/2/2023, and prays for allowing some more time. Stop considering the submissions, the prayer is allowed. The petitioner is directed to take fresh steps for issuance of notice upon the opposite party by registered post with the AD as well as by usual mode within 3 days. Within 7 days from the date of this order, returnable on 25th of April 2025.
May I please, Your Lordship? My lord, as per office note, my lord, we have steps has been taken to the respondent, my lord, and services are awaited, my lord. So may I pray before Your Lordship and to allow me to take dusty service to the respondent, my lord, because the respondent here is my wife, my lord.
Okay. Heard Mr. D.J. Haloy, learned counsel for the petition. Wife, but what is the dispute between you?
My lord, an ex parte order was passed.
Ex parte 125.
Maintenance, my lord, 125 proceeding, my lord.
Okay. Heard Mr. D.J. Haloy, learned counsel for the petitioner. He's as per the office note dated 10/3/2025, he submit, it appears that the service report in respect of the notices issued to respondent number in respect of the sole respondent has not yet returned. Await further. This learned counsel for the petitioner submits that since this criminal petition is directed against an order passed in a proceeding under section 125 of CRPC against an ex parte order in a proceeding under 125 CRPC. He may, and as the opposite party is his wife, he may be allowed to serve notice on the respondent by way of dusty mode. The prayer is allowed. The petitioner, in addition to the petitioner, is allowed to take steps on the respondent by way of dusty, and after service of notice on the respondent, he shall file an affidavit of compliance. The petitioner shall take steps within 3 days within a week from the date of this order, returnable on 11th, returnable on 22nd of April.
My lord, I have an interim prayer, my lord, and earlier that Your Lordship has not considered, my lord, that my lord, I may be allowed to pay rupees 4,000 per month to my wife, my lord.
No, what do you do?
I have a tea stall, my lord. small tea stall at the Sansari area, my lord. And it is not disputed, my lord, by my wife. And she also stated
No,
this,
let
my
the
only case is that. my
1
lord,
month, it is a matter of only 1 month.
My lord,
It is a question of matter of 1 month
my
only.
lord.
So pay 4,000 more for this 1 month. After due service of notice.
Highly obvious. Item 44.
Made to the lordship.
Admission Kimanafi. Yes, item 44.
This matter, my lord, if your lordship remembers, it came up day before yesterday. my lord. This matter pertains to my lord the assault on the.
It is there.
Series there. my lord.
Now against each of the petitioner, what materials are there? You have to see.
Not, my lord, it was a market area. The owners of various shops, they were examined. Nobody could identify them, but the IO from the video footing identified some of the petitioners and affirmed their, my lord, presence at the place of occurrence.
Presence only.
Presence at the place of occurrence from video footage. The petitioner number 1,
No.
3,
Whether the victim has been examined.
victim examined, my lord. Victim examined,
he
he
has
has not
named-
named anybody. He is a police constable, my lord.
He has not named anybody.
Not named anybody. And my lord, I have collected through WhatsApp the injury report also. There, the person was, my lord, medically examined. Simple injury, my lord. Says pain and tenderness.
So what is your submission?
My lord, basically, this is, my lord, occurrence took place due to political rivalry. Now I am, my lord, forwarding some independent witness statement.
They have implicated or not? Okay,
Like not,
okay.
but
Heard.
one thing, my lord, because political rivalry is there, my lord, it's otherwise sensitive case.
No, it is a simple
My no
case of-
objection may not be recorded.
Heard,
Well,
Mr.
out of the
S.
10, well, out of the 10 petitioners, my lord, recently petitioner number 4 and 10, they have surrendered. my lord. So there are 10 petitioners, my lord. Out of them 10, my lord, now 4 and 10, they have surrendered, my lord, and they have been forwarded also.
4 and 10.
4 and 10.
Yes.
Basiruddin and Abdul Khaled. These 2 persons. So
These 4 and 10 were present, my lord, as per video footage.
Heard. Heard, Mr. S. Das, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 482 of BNSS has been filed by 10 numbers of petitioners, namely 1 to 10 Likibo, who are apprehending their arrest in connection with Rupohi PS case number 67/2025 under section right from the so-and-so. Learned counsel for the petitioner. What is your submission?
my submission is that, my lord, they are, my lord, residents of that area, my lord. So, my lord, even if their presence is there in the video footage, my lord, they were not, my lord, direct participants in that assault, my lord. They may be there, my lord, but they were not involved in the offense.
The gist of accusation in this case is that on 20/2/2025, one Jitumani Bora had lodged an FIR before the officer in charge of Rupohi Hat Police Station, inter alia, alleging that the informant is engaged as a personal security officer of Mr. Rokibul Hussain, who is the member of the parliament from Dhubri Lok Sabha constituency. And on 22/2025, when the informant accompanied Mr. Rokibul Hussain to Gunabari village for attending meeting of Congress party. And when they reached Rupohihat High School, some miscreants carrying hockey sticks forcefully stopped them at Notun Bazar area and assaulted whether assault was there on the
Yes, sir.
on the member of parliament also,
My lord.
whether Mr. Rokibul Hussain was assaulted.
My lord.
He has lost another affair in.
No, in this case.
In this case, that is, so far witnesses stated, my lord, there is pulling and pushing, my lord.
Where he has been
Yes.
pushed and pulled last time.
Pushed and pulled.
Mainly the
Assault
FIR
word
is
is not
regarding my
used.
lord assault on the TSO. My lord.
Mr. Rokibul Hussain was pushed and pulled by the miscreants, and at that time the informant along with other tried to protect him, and during that commotion, during this said pulling and pushing, the informant was assaulted with hockey sticks by the miscreant. So, learned counsel for the petitioners has submitted that though this bail application has been moved by 10 numbers of petitioners, however, in the meanwhile, petitioner number 4, namely Basir Uddin, and petitioner number 10, namely Rasidul Islam, have surrendered before the IO or court.
Before the court, man.
Before the court, and they have been remanded to judicial custody. So, as regards other petitioners are concerned, learned counsel for the petitioner has submitted that they are the local inhabitant of Rupohihat, and they only gathered to witness the incident when the member of parliament visited the said place and there was a commotion. The petitioners, learned counsel for the petitioners submitted that the petitioners are innocent villagers and in no way involved in the offense alleged in the FIR. It is also submitted by learned counsel for the petitioner that the petitioners are ready to cooperate with the investigation and their custodial detention may not be necessary for fair completion of the investigation. On the other hand, learned additional public prosecutor has produced the case diary of Rupohiyar PS case number 67/2025 and has submitted that there is evidence on record regarding presence of some of the petitioners at the place where the incident occurred. He, however, fairly submits that the that the only one was injured,
Only one.
that the injury report of the person who got injured in the incident shows that he suffered simple injuries. The injury report has been produced by the petitioner, by the learned additional public prosecutor. A copy of injury report has been produced by learned additional public prosecutor for perusal of this court. Same is marked as X and placed in the case record. Stop. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor and have gone through the case diary of Rupohiyar PS case number 67/2025. On perusal of the case diary, it appears that apart from the evidence regarding presence of some of the petitioners at the place where the alleged incident occurred, no other incriminating material is there against them at this stage of the investigation. Further, considering the fact that the injured in this case sustained only simple injuries and as well as the investigation has not progressed much.
My lord, investigation is on, my lord. Not completed.
As well as the stage of investigation. The custodial detention of the present petitioner at this stage does not appear to be necessary if they cooperate with the investigating officer. Stop. In view of above, the above named petitioners, Nam Dibo, all names except 4 and 10 are hereby directed to appear before the investigating officer of Rupohiyar PS Police Station, case number 67/2025, within a period of 7 days from the date of this order and cooperate in the investigation. If they do so within the stipulated period of time, in the event of their arrest in connection with above noted case, the above named petitioners shall allowed to be go on bail of rupees 30,000 each with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1 and 2. Send back the case diary. This bail application is accordingly disposed of.
I just took instruction, my lord. 4 and 10 appear before the police directly, my lord, not before the.
Okay. Before the court petitioner, not before the police.
Highly obliged.
None has appeared for
Your lordship, this matter pertains to our solution.
list this matter before any other bench without me, within bracket my name.
Item 19.
No, kindly the matter may be passed over for the time being. My senior will be coming.
Let us pass over it for the day.
No, Lordship, we very urgently want a stay order in this case, Lordship. The case is pending before the trial court. The respondent number 2 has already appeared. On the first day of the motion, it was stated that means the interim order will be granted on the appearance of the informant.
We have submitted our objection.
We will be filing our reply, but until then, the stay order may be granted, please. Otherwise, NBW notice will be issued.
Maybe, you know, I think my friend might have brought to your notice something. Problem is that I am working as a postmaster. And during that time, my lord, a fixed deposit was done with the post office. And it was matured, fine matured, he came. Now, there is offline and online.
I'll put God's eyes here. Can we hear it for final disposal?
Any date, Lordship, or objection.
Today?
We have filed our.
But till that, my lord, because I have to go to every day to the court, every 15 days, 20 days. That is the problem. I cannot,
No, if you are ready, we
what
will.
is my wrong, my lord? That is the problem.
No, I am ready to hear it for final disposal
Yes,
today.
Let it be next week, Lordship.
Sir, the case is settled. Case is
On Tuesday.
Tomorrow is the date I have to go. That is the problem. my lord. Till that 15 days operation of the.
Today, you are not ready.
I'm ready, Lordship.
You
I'm
are
not
ready.
ready to-
Yes.
Then let us hear it. We
Yes.
will dispose it now, finally.
I'll do.
At least we can hear one method.
Yes, my lord. Now, my lord, the question is that when a post office, from a bank manager, suppose, my post office, my lord, when savings account is open, fixed deposit is done, it is supposed to be returned after maturity. Now, my lord, as per the provision of the postal department, we are being guided by the head office, superintendent office at Silchar. We are under Silchar, not Silchar locality. Then, my lord, when he has applied, we have immediately sent the message, you send the maturity. Then, my lord, in the meantime, my lord, he did not aware. He filed a case against us. That is a misappropriation of fund. How misappropriation? We are always asking you, come and collect your money, collect your deposit amount. He is not coming. He has filed a case for which I filed a revision before the section judge. Section judge said, no, we will not interfere. You face the trial. Against that, we have come before your lordship. Now, your lordship, kindly tell me what offense I have committed. How 406 will come up? Did I misappropriate the government money, my lord? Now, my lord, I take your lordship page 23 kindly. Page 23, kindly, my lord, take little pain to come to page 23, annexure 8. To the post sub postmaster Patrakande. Regarding permission for manual
Yeah,
payment,
Just a minute. Page 23.
23
What is,
of my petition. Regarding permission for manual payment of NSC and KV certificate with reference to your office letter dated nil. Dated, so regarding the permission to manual discharge
no,
of the
what
certificate,
relief you are seeking?
page 23.
What relief you are seeking? Quashing of the
Yes,
proceeding,
washing of the proceedings.
entire proceeding.
Yes, or so for the timing, it should be state matter. And he should take the money. We are government of India is not so poor that a small amount they cannot return. Till now, government of India has not become bankrupt. And I being a postmaster, I have got some formalities. I have to take permission. That's why I have written this letter. Whether manual payment can be done. My bona fide kindly peruse my certificate. You are hereby permitted to close the below mentioned certificate manually as per the extant rules after consulting all the relevant office records at the earliest and report compliance to this office. This is the letter came to us, my lord. 14/8/23. Then, my lord, thereafter,
Why this letter is relevant?
beg your pardon?
What is the relevancy of this letter?
Because, my lord, there is a offline and online system. For payment, we have to take the superintendent office signature.
What is the name of the respondent?
Shakir Ahmed.
Shakir Ahmed.
He was our valued customer, my lord. We are always ready to cooperate. NSC and KVP. These are 1,000, 1,000, 1,000. And he has been matured. We want to pay him with interest. He has filed the case and not taking even file. No prejudice. He can
Where-
take the money now. We will give.
Where is this?
Beg your pardon.
Where is the document
Regarding,
regarding your willingness to pay?
well,
That you
there is an order from to discharge the matter. Yes, page 23, it is a say superintendent of post office Silchar,
August 23.
August 23. As per extant rules, after consulting all the relevant officers. Oh. You have the case file कर दिले.
Yes, filed a case before getting this permission.
Yes.
And the money is only 2,000.
Yes. They are spending thousands of rupees in court proceeding.
Okay.
But one judgment I want to place. But here you will find that
No, now what is the allegation made by the complainant?
they are saying that I have misappropriated the amount, that's why I am not paying.
No, where is the allegation?
That is the criminal case.
Let us go to the
Complaint
FIR or
case.
complaint. What is the relevant?
I'll show my.
Page number 14, man.
Page number 14.
Page 16, below the allegation, para 6 of the complaint. The complainant has advisable suspect that both the accused persons in connivance with each other have misappropriation the due payment of the complainant. আপনি এই লেটারখন গাঁথা নাই
হ্যাঁ?
এই লেটারখন গাঁথা নাই আপনার
তেওঁলোকেই দিছে।
না না উইথ রেফারেন্স টু অফিস লেটার আপনি
দিয়া নাই আমি দিয়া নাই।
দিব লাগিছে
প্রথমে আমি শিকারের পরে ব্যাপার।
কিছুমান গাঁঠি বলে আপনার লেটার রিপ্লাই এখন দিছে না
This is a CR case or police PRC?
সিআর কেস
Okay.
With interest, they will get the amount, my lord. We are ready. Government of India is ready to pay at any time.
Yes, anything else?
Well, the judgment I am placing, my lord, the court cannot issue the summon in that manner. There is a judgment of FX court, my lord. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that the complaint has to be bring only two witnesses to support his allegation in the complaint to have the criminal law set into motion. The order of the magistrate summoning the accused must reflect that he has applied his mind. In this case, our country is that landed magistrate was issuing the summon, his application of mind is absent.
Why,
You-
whether
Yes,
complainant was examined under 200?
yes. Document in
Yes,
support
yes,
of their,
Yes or no?
That is an full.
And any other witness?
no other.
No,
In taking recourse, my lord, serious process, this
Yes.
court has constantly held that magistrate must apply his mind on the allegations of the commission of the offence. Darshan Singh, my first state of Maharashtra, my lord, whole. Then, my lord, in another case, my lord,
two witnesses examined.
Page
Page
I
18
am
and
placing both the judgment to your lordship. In a Suril Mittal's case, my lord, I take your lordship to relevant para, my lord, page 9, para 19. Para 19. Page 24, my lord. Sunil Mittal's case, my lord. The expression of cognizance has not been defined in the courts, but the word is in indefinite import. It has historic or mystic significance in criminal law. It merely means becomes aware and when used with the reference to a court.
No, Mr. Vishwas,
Yes, madam.
the accusation made against you is that even after getting sanction for manual payment by the letter which you have referred, you have not released the money.
It is not correct, madam.
That is the statement.
It is not the correct, madam.
Now, correct, whether it is correct or not, in exercise of 528,
How can I be held responsible? Chairman will be, Postmaster General will be responsible.
that plea you
How
have,
can they make me accused, madam? Union of India is responsible.
no, they have made accusation against you. They have, their case is that there is no bar in paying back their money, but you have held the
Why
money.
should, madam, what is my interest to held up
No, I don't
his
know,
amount,
but
madam? No, no
that is
interest
the
there.
accusation.
No interest is there. We are willing to pay with interest at any time he comes. Now, this type of dragging an postmaster to the court, my lord,
Okay.
এখন আপনি লিখেছেন নাকি?
Yes,
sir.
anything else?
my lord, I have placed two judgments. Kindly peruse these two judgments. Whole procedure was wrong, my lord. Learned magistrate, while issuing the process, they had to follow some.
What was not followed here?
My lord, that is the expression, my lord, cognizance regarding is defined as not defined in the code. But word cognizance is a indefinite import. It has to historic and mystic significance in the criminal law. It means become aware when used the reference
No,
to a
no,
court
Mr. Vishwas.
or judge. It connoted that to take notice of
Mr.
judicial.
Vishwas.
Yes.
Where the trial court erred, what mistake it committed? You
No, my
point out,
submission is that while issuing the process, no reason has been given. You see the order. Whether his satisfaction is there, have to give a satisfaction, madam.
and anything else?
Then, my lord, my bona fide you have to consider, madam. My bona fide. I want to, this is a government of India, you want to return the money. It is a kind of harassment. Very difficult for us to take the deposit of some person if they do like that.
Yes, Mr.
Judicial Magistrate Karimganj, as well as the additional Session Judge Karimganj have failed to appreciate the fact that summoning an accused in criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. The order of the magistrate summoning the accused must reflect that he has applied his mind to the fact of the case and law applicable thereto.
Which para you are reading?
I am reading para 15 of my page, my lord. Page 26, page
15.
7 of my petition. Para 15 of my petition, division.
Okay.
The nature of allegation made in the complaint and the evidence, both oral and documentary, in support thereof, and would that be sufficient for the complainant to succeed in bringing charge home to the accused? It is, if it is not, the magistrate is a silent spectator at the time of recording the preliminary evidence before summoning the accused. The magistrate has to carefully scrutinize the evidence brought on record and may even himself put question to the complainant and his witness to elicit answer to find out the truthness of the allegation or otherwise, and even examine if any offense is prima facie committed by all the accused persons. Pepsi food case, my lord, I have referred, my lord. Pepsi food case, Supreme Court, my lord, I have given reference page 8, my lord. Then the learned court below also miserably failed to appreciate the fact that a recording of region by magistrate in summoning under section 204 CRPC is mandatory. Otherwise, summoning order would be set aside. That is Sunil Sunil Bhatti Mittal's case versus CBI, AR 2005, Supreme Court 923, my lord. That the learned magistrate as well as the learned additional session judge Kadimon have failed to appreciate the true meaning of the section 409.
Where is the order of the additional sessions judge?
I'm giving my lord.
Page number?
If I'm not wrong, Lordship, that has not been. Page 21. Additional session.
Yes, my lord. Page 21. Case record is received on transfer. Revision is represented, hard, perused, seer, on perusal of the material available before me.
This is the
It is
initial
found that the
order.
revisionist has challenged the legality of the order dated 17/7/23.
Mr. Vishwas.
Yes.
This is the first order. This revision has been disposed of.
Yes,
Where is that order?
My lord, that order has not been annexed, Lordship.
I'm giving one. I'm giving. But I'm giving one.
This is under challenge,
Yes.
but this is not an.
Not annexed.
But this order, input order was challenged. By way of,
This is the impugn order.
Judgment in the.
no, my lord, there is a order sheet order is the 28-3.
28.3 is not,
No.
28.3 is the order of filing revision only.
No, Lordship.
No, my lord, page 22 is there, madam. Page 22. Both these parties are represented. Judgment is prepared in separate sheets, delivered in text with seer. In the result from the facts and circumstances of the case, I hold that.
You
Impugn order
committed a
17/7/23.
mistake.
Yes.
Unless you bring the order which you are impugning on record.
That is the under challenge. And that has not been annexed.
I'll file an affidavit and file it.
File it.
I want it back.
Heard Mr. S.C. Vishwas, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor as well as Mr. M. Ahmed, learned counsel for respondent. Number 2, learned counsel for the petitioner has prayed for allowing the petitioner to bring on record the order dated 1/7/2024 passed by learned additional sessions judge Karimganj in criminal division number 45 of 2023 by filing an additional affidavit. The prayer is allowed. When?
Date may be fixed by within 15 days, I'll file.
Why you take 15 days?
So I have to send the affidavit there, my lord.
Okay.
He's working there.
Let this case be listed again.
But my lord, I'm interested. In our reply, my lord, we have annexed this judgment. Kindly. In our affidavit.
Our objection, Lordship.
Oh, no, I'm sorry. We want to file an objection also, my lord. We'll annex it here.
Let this case be listed again on.
We have sent it for his signature, affidavit showing it.
On 28th of March, or you want in first week of April?
My lord, tomorrow is a date fixed, my lord.
You appear there because
I'm appearing, my lord. I'm appearing, but every day.
because your petition is defective. 28th of March.
Oblige.
May please the lodge.
What is the matter?
My lord, we have filed this petition for quashing of entire proceeding, my lord. My lord, the case was filed, my lord, on 2/12/2021. Both the girl and boy, my lord, they are measured. Girl 20 years, about 20 years, my lord, boy 24 years. They had love affairs and they developed relationship. With the view that they will perform their marriage. Boy was, my lord, unemployed, so he did not consent for marriage. Then she filed FIR. And during pendency of the case, my lord, they have solemnized their marriage. And they have, my lord, filed compromise petition also, my lord, then she will not continue with the proceeding. And otherwise, if your lordship consider the FIR also, my lord, 376, my lord, in this case will not come. Because entire thing is on consensual basis.
Where is the FIR?
FIR, my lord, page 15.
You are opposing?
No, Lord.
Now they are living as husband and wife, my lord. Marriage certificate we have annexed, my lord.
What case you are relying?
We are relying, my lord, very recent judgment, my lord. And
Lakshmi Narayan is there.
regarding, my lord,
Kuntu?
Yes, let him cite. No, whatever you have, on what matter you are relying.
Notun judgment. My lord, this, my lord, very recent judgment regarding, my lord, promise on marriage. And regarding compromise, my lord, this one from small Supreme Court. Right condition there.
What it says.
My lord, after compromise, my lord, marriage was solemnized, then compromise. Then this all court, my lord, by exercising power, my lord, was the proceeding.
No, you have to show that in exercise of inherent powers of the court under 528, even if offense involved is 376, still under some circumstance, it can be quashed.
On compromise.
On whatever ground it may be quashed. This is a different case. You cite, I am reserving the judgment.
Or should I give the judgment?
You give the judgment.
And the latest
You are
judgment,
not
my lord,
opposing.
No.
Mr. Das,
If Mia Bibi Razi, my lord, what will do Kazi?
no, sometime Kaji may not allow it.
That is, but allegation is not that they are minor. Had it been the
Okay.
minor, I would not have followed.
Okay. Heard Mr. R. Ali, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor, as well as Mr. M. J. Shah, learned counsel for the respondent. Number 2. Hearing, when will you give?
and that was last book.
You give it to the court master.
Lordship will punish.
I am reserving the judgment. Hearing concluded, judgment reserved.
Deeply.
Okay, decision, my lord, the appeals to the appeal, my lord, against the judgment dated 25/11/2004, my lord. Convicting the, my lord, appellant for commission and offense under section 8 of the POCSO Act, my lord.
Under section?
8 of the POCSO Act, my lord. For 3 years, my lord.
Notice has been issued to?
My lord.
No.
No, my lord.
Today is the first date.
First day, my lord.
Okay, heard Mr. M. Saronia, learned counsel for the appellant in appeal. This appeal under section 415 within bracket 2 of BNSS has 2023 has been filed by the appellant Mukha Basumatari, impugning the judgment and order dated 25/11/2024 passed by learned special judge POCSO within Sirang in special POCSO case number 4/2024, whereby the appellant was convicted under section 8 of the POCSO Act and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 20,000 and in default of payment of fine.
There is one IA, my lord, to suspend the. It's been ordered.
Now we are issuing notice. After service of,
He is already on bail, 3 years punishment. will be.
oh, you are on bail.
Bail, my lord. I have to connect the order, my lord.
Please,
So that previous bail will be allowed to continue
My lord,
till rece-
still returnable, or my lord, appearance
Heard.
of private respondent.
heard Mr. M. Soroni, learned counsel for the petitioner. This interlocutory application under section 430 of BNSS has been filed by the petitioner for suspension of sentence imposed on him by the Court of Learned Special Judge Poxo Sirang in special case number 4/2024, whereby the petitioner was convicted under section 8 of the POCSO Act and was sentenced to undergo rigorous imprisonment for 3 years and to pay a fine of rupees 20,000 and in default of payment of fine to undergo further imprisonment for 1 year. The said judgment of conviction and sentence has been impugned by the present applicant in connected criminal appeal number 45/2025. Stop. The aforesaid appeal has already been admitted for hearing. Stop. Learned counsel for the applicant has submitted that the petitioner is, the applicant is already on bail granted by the trial court. Stop. Issue notice to the respondent. Number 2. The petitioner shall take steps, the applicant shall take steps for issuance of notice upon the respondent number 2 as per the prevailing notification of the registry in this regard within 7 days from the date of this order, returnable on ki date asil appeal 25th of April. Till the next returnable date, the petitioner, the applicant is allowed to remain on previous bail granted by the trial court.
Is an excerpt to of the IA, my lord.
List accordingly.
Hello.
Madam, it's a criminal appeal. Conviction is under section 8 of POCSO Act. And he has been sentenced for 3 years punishment.
You are behind the bar or
My lord?
you are on bail?
No,
or-
I'm on bail.
Heard Mr. D.K. Bhattacharya, learned counsel for the appellant. This appeal under section 415 of BNSS has been filed by the appellant, namely Dukle Bhakat, who has been convicted under section 8 of the POCSO Act,
Read with 341 and 354.
as well as under section 341 and 354 of the Indian Penal Code by the Court of London Special Judge POCSO in special case number 30/2021. Stop. The appellant has also been sentenced to undergo simple imprisonment for
1 month under 341 IPC.
for 1 month under section 341 of Indian Penal Code, as well as 1 year under section 354 of Indian Penal Code. And also to pay a fine of rupees 2,000 and in default of payment of fine to undergo simple imprisonment for 2 months under section 354 IPC. Stop. The appellant is has also been sentenced to undergo simple imprisonment for 3 years and to pay a fine of rupees 5,000, and in default of payment of fine to undergo further simple imprisonment for 2 months under section 8 of the POCSO Act. This appeal is admitted for hearing. Let the records of special POCSO case number 30/2021 be called for from the trial court. Issue notice to respondent number 2. The appellant shall take steps for issuance of notice upon the respondent by, as per the prevailing notification in this of the registry in this regard, within 7 days from the date of this order, returnable on 30th of April. In the IA, is there any bar in allowing the applicant to remain on previous bail?
As per the judgment, 7 years is short sentence. So
No, that is okay. But should fresh bail should be allowed, or he can be allowed to remain on?
3 years.
Yes, because he is.
He's already on bail.
Yes, yes.
Okay. Heard Mr. D.K. Bhattacharya, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. This application under section 430 of BNSS has been filed by the applicant for suspension of sentence imposed on the applicant by the judgment which has been impugned in the connected appeal, that is criminal appeal number 83/2025. Issue notice to the respondents. Respondent number 2, the applicant shall take steps for issuance of notice upon respondent number 2 in pursuant to the prevailing notification in this of the registry in this regard. You are on bail?
I am on bail.
Where is there an
My
order?
lord, that order I could not get, but otherwise the judgment says I'm on bail. My lordship takes page 10, page 11. I had been in bail for only 42 days and presently I'm in bail because Wakalatnama is not from the jail.
Learned counsel for the petitioner, learned counsel for the applicant has submitted that the applicant has.
Yes, for impugned judgment also, the bail bonds are not discharged.
Yes,
So he may be.
He's on bail granted by the trial court. Stop. Still, till next returnable date, the applicant is allowed to remain on the previous bail granted by the trial court, list accordingly.
May I please, your lordship? This appeal is again a conviction, your lordship. Under section 304 part 1 here.
Under section,
304 part 1 here.
what is the sentence?
Sentence for 10 years and to pay a fine of 5,000 in the and simple imprisonment for 3 months.
Heard Mr.
R.
R. Chetri, learned counsel for the appellant. This appeal under section 415 of BNSS has been filed by the appellant who has been convicted, appellant Romain Bhuya, who has been convicted, by the appellant Romain Bhuya, impugning the judgment and order dated 20/12/2024, passed by the Court of Learned Additional Sessions Judge Jorhat in Sessions Case number 30/2023, whereby the appellant has been you have mentioned wrongly
Initially, your lordship, that FIR case was trial under section 302 and
But conviction is
convicted
not
under
under,
304.
has been convicted under section 304, part 1,
Part 1.
part 1, and has been sentenced to undergo rigorous imprisonment for life for 10 years and to pay a fine of rupees 5,000, and in default of payment of fine to undergo further simple imprisonment for 3 months. This appeal is admitted for hearing. Issue call for the records of the Sessions case number 30/2023 from the trial court. Also issue notice to the respondent number 2. The petitioner shall take steps for issuance of notice upon the respondent number 2 by registered post with ID as well as by usual mode within 3 days from within a week from the date of this order, returnable on 30 April 2024. You will file objection 10 years.
Let the LCR come first,
Okay.
because without examining the LCR, it is difficult to file. Today notice may be issued on
Yes.
IA, my lord.
I for suspension.
In I, this heard Mr. R. Chetri, learned counsel for the applicant, also heard Mr. D. Das, learned additional public prosecutor. This interlocutory application has been filed under section 430 of BNSS 2023, praying for suspension of sentence imposed on the applicant by the judgment and order dated 2012-2024, passed by the Court of Learned Additional Session Judge Jorhat in Sessions case number 30/2023. The aforesaid judgment has been impugned by the applicant by filing the connected criminal appeal, that is criminal appeal number 84/2025. Stop. The said appeal is already admitted. Stop. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to the said respondent. As against respondent number 2 is concerned, the petitioner shall take steps for issuance of notice upon the said respondent by registered post with AD as well as by usual mode within 7 days from the date of this order, returnable on 30 April 2025. Please record.
All right. May it please your lordship. Lordship, can peruse the last order, lordship. Here I am challenging the lordship framing of charges under section 376(1), lordship. Because the FIR, lordship.
Scan copy was called for.
Scan copy of the
Scan
case
copy, I say.
case diary.
Scan copy has arrived.
Scan.
हमारे
Case
पास
diary
scan
copy. Case diary copy.
case diary की charge
Scan copy of the case diary would be,
case वाले case diary की नहीं है.
case diary would be required. Scan copy of
Scan
the
copy of the case diary.
Case diary.
Well, as it appears from my brief, my lord, scan copy was called for by.
yes,
The last date case diary also called for.
scan copy of the case diary.
Scan copy of the case diary.
Case diary.
That also called.
It has not arrived. Heard Mr. B. Chaudhary, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. On perusal of the office note dated 10/3/25, it appears that the scanned copy of the case record of case diary of Tamulpur PS case number 13/2024, as well as case
Informant of party को
case record of sessions case number 142/2024,
second question होले informant of party
which was called for in connection with this case, has not
charge sheet file वैसे no.
been received. issue reminder for this.
Yes, offense.
Offense initially.
Let this matter be listed.
376 one was it? Well, may I, sorry to interrupt, Your Lordship. Well, he has come for washing of the charge sheet.
Washing
Not-
of the charges.
Hmm?
Washing of the charge and 376. That is on page 15, the order.
Now, your informant is not made party here. Now, whether he will be.
76
party.
probably Lordship informant need not to be made a party.
No,
Lordship.
informant has right to
Participatory right is there.
Participatory
But
right
the
is-
Apex Court has declared participatory right. He should make party, after
Because
service of notice, if doesn't come, that is all right.
Then
learned additional public prosecutor submits that in this case, informant has not been made a party. Informant or victim has not been made a party who have the participatory right. And it is indisputed that they have participatory right in the proceeding, in the present proceeding. Hence, the petitioner is directed to implead the respondent, implead the victim / informant as respondent number 2, and thereafter issue notice upon the said respondent. Now, first you make party.
Yes.
Thereafter issue notice to continue. The petitioner shall submit an amended cause title to this criminal petition,
Yes.
including the informant / victim as a party to this case. Let this case be listed again in the next week on a date to be fixed by registry.
can we do the first week of April, Lordship?
Let this case be listed in the first week of April on a date to be fixed by registry.
Publish.
Zimma.
May I please, Your Lordship? The Jimma report was filed.
This case, my started was already submitted by in this case.
Okay. Now, what is the case?
Case, my lord, it's a stolen one, so theft case, my lord.
You are the owner.
No, my lord, actually, he is my lord, he is claiming the Zimma, my lord.
On what
He has paid
basis?
for Zimma, my lord, because my lord, the person, my lord, from whose possession the vehicle was recovered, my lord. They have implicated that he is the owner of the vehicle, but when he was asked to appear before the police, my lord, he could not produce any documents, my lord.
Where are the documents?
That is why, my lord, he has paid, his Zimma was rejected by the trial court.
Here, on what basis you are seeking? What is the basis on which you are seeking Jimma, praying for Jimma? Not ready. Not ready.
Take this matter after some time, Lordship. My senior is.
Not after some.
Not after some time. You come prepared. Oh, what is your name?
Islam.
Huh?
Islam.
Speak loudly.
Islam.
Heard Mr. I. Islam, learned counsel for the petitioner, also Mr. R. J. Borwal, and an additional public prosecutor. The petitioner, learned counsel for the petitioner, prays for some time to go through the brief and before he makes his submission in this case. The prayer is allowed. Let this case be listed on Tuesday, on 13 Tuesdays, 18/3/2025.